Hey, good morning, everybody. Before we get started, I just wanted to say thank you to everybody. You know, I just said in the pre-show 13 months ago, this whole channel, the Courtroom Files, was not even on my bingo card. And now, a year later, we have a bingo game that revolves around court. It's all just been crazy and wonderful. And it's been one of the best years of my life, and I have all of you to thank for that. This would not be the same without all of you because of the tremendous community that we've built. Not only the support that you show me, but the support that you show to each other is just absolutely outstanding. And I just wanted to say thank you. It's been a great year. I look forward to the next one, and let's roll, nerds. Good morning. Happy Friday. Welcome to the Courtroom Files Live. It seems appropriate to me, since it is the 1 year of this channel, that we start our day with the first video that I ever produced for this channel and that I ever published. This was out of Judge Fleischer's court 1 year ago, and it's gotten over 30,000 views since then. Not necessarily our best performing video, but it was the first. So let's start there, and then after that, we'll move into what's going on in the courtrooms today. Except for some reason, there's no audio. This is a professional show right here. Let's not forget that. Why is there no audio? I know why there's no audio. Well, maybe I do. That's weird. That's weird like the moon. I'm going to play it again. Tell me if there's audio. Doggone. Why? There's no reason. All right. Well, you know what? Maybe we'll come back to it later. See? This is the thing. This is why you come here, folks. You come here for the, oh, I know why. I just figured it out. Let's try this again. See, this is what I've learned over the year, is I've learned that stuff happens and you just roll with it. So I'm rolling with it. Here we go.
Shreya.
Back again, Judge.
Okay. Dave, we're always happy to have you.
That's just, you know.
Hi, Shreya.
Hi, February Campbell requesting a bond.
Okay.
I'm going to be opposed. He's wanted for manslaughter, 2 counts of aggravated assault.
No, Judge. Okay, it's anyone can get into in a car accident.
Hey everybody, welcome to the Courtroom Files. So in this video, the defendant, Kevroyd Campbell, is in front of Judge Fleischer looking for a bond. He was picked up at an airport in Houston on his way with his family to what he says was vacation. He is wanted out of the state of Arizona for manslaughter, as you picked up in the intro. Now, we're based in Arizona, so I did a little digging on this guy, and he has not been arraigned from what I can tell on these charges, so they are very fresh. What my question is for this particular person is, you'll see in the video that he claims that he was told by his lawyer that he could go on vacation. I find that hard to believe, if he has any quality of a lawyer whatsoever, that they would tell him with a pending manslaughter charge and a potential warrant to just leave. But I'd be curious what your thoughts are. So give the video a look and give me your thoughts in the comments. What do you think about his excuse for why he was traveling and then picked up on this warrant? So we are a new channel here. We've been on YouTube forever, but this is a brand new venture. So please do us a favor if you enjoy this video. Consider subscribing to the channel. Certainly put a like on it and leave comment in the video if you would, because these things all help us get found by others who might enjoy it. Thanks so much and enjoy the video.
Morning, Mr. Campbell. How's jail?
Not very good.
Good. That makes me happy. You know, what I find at least, the worse of an experience you have, the higher likelihood you have of actually, when you get out into the free world, of thinking about consequence, because that's what we want everybody to do. Think before you act, think before you speak, because you never know when it's your last time. All I know now is that you're wanted out of another state. You're wanted out of the state of Arizona, specifically Maricopa County, for manslaughter, 2 counts of aggravated assault and endangerment. Day,
Yes, Judge.
tell me about Mr.
That's all I have so far. I do show a Georgia state ID, which I didn't see at first, but I don't see any history originally. I believe this is only offense, but because of the severity of the offense and with the warrant stating that while there is $150,000 bond, is that they're requesting no bond until he's in front of a magistrate within their state. And so because of the severity of the offense and the risk of flight, is that state requests no bond for this defendant.
Is this a 2B?
This is to be judge. It was issued out on September 25th, 2024.
Okay. And the bond over there is at 150,000.
150, but they will not permit it to be honored until he goes in front of a magistrate within their court.
Okay. Do you know what the manslaughter is about?
No, I don't have the probable cause affidavit, but if you're looking for specifics, I can request it from the DA's office, but I don't have it at this time. I just know that the charges are valid.
Do you have anything that you'd like to add?
Yes, Judge. Mr. Campbell actually hired an attorney, is known about the investigation, so this was not an instance where he's trying to run. The attorney told him they could take a family vacation. So he was arrested at a connecting flight in Houston with his wife and 3 children. So he wasn't trying to run. He was going on a family vacation. His attorney there told him.
We were on the way to
the family. He doesn't live in Houston.
be going.
So essentially, he gets arrested in the connecting flight process. He's not from Houston. He is ready, willing, and able to go back to Arizona. He's got his attorney set up there. If he gets out, it's not like he's legitimately gonna stay at a hotel and then the next day get on like a bus, because we talked about the flight problem. And he has a vested interest going back. He's 41 years old. I think he has a license case from like 15 years ago, nothing else. Wife, 3 kids in Arizona. He's got 2 prior children in Georgia, but he has like a family life and a business in Arizona, lives there. So he absolutely wants to get back to Arizona. And with that in mind, we would be requesting a bond here so that he can just go back and turn himself in.
No, Mr. Campbell, I really value my city, and I want to protect everybody I can for as long as I can, because the last thing I want is more death, more destruction. And you're wanted for something where there's a dead body.
Oh, sorry, Judge. It just pulled up just now. So Trey is correct. There was a suspended license, but he also had a prior hit and run and failure to stop and return to scene, which seems aligned with the manslaughter and 2 accidents with the vehicle and the
Is that
driver.
with this case or another
No,
case?
sorry, Judge. This is back in Georgia. So after the license suspension, there are 2 cycles. Hit and run, failure to return to scene. There's also DWI back in 2014.
Wow. Continues to happen.
I don't know what happened to that one though. It just.
You want me to set you a bond? Silly?
I had to run the state ID. It
Can I
wouldn't pop up
speak?
on the other side.
Yes, absolutely.
Sir, those cases were like thrown out. I didn't, whatever he has there, the DWI,
I know.
I never had a DUI. And with the hit and run business, that wasn't it.
How do I know that? Am I supposed to take your word
For
for it?
that thing, my car was stolen, sir. And then they assumed that, it's like how here they're assuming that I'm trying to run from.
No. No one's assuming that you're running. No one's assuming that you're running. All we know is that you are wanted out of Arizona, where there's 2 aggravated assaults and there's a manslaughter. So there's a dead body, right? And you also have priors out of another state where there's alleged DWIs and you running from the scene. So my problem is that I have no idea what the circumstances of the manslaughter are. How do I know you didn't shoot someone? How do I know you didn't run someone over in a car at a parade? And so it would be really just dangerous for me to really give you a bond and just let you go when I don't know how dangerous you are. Do you know what I mean? That's just, it's logic. As much as I'd like to get you back to Arizona as quick as possible, Mr. Campbell, you scare me. How soon can we get Arizona to come pick him up?
I don't know, Your Honor. I mean, well, for him, because he originally waived the magistrate, I know they've already.
He's waived.
Yes, I believe he waived 2 days ago when he went to.
Great.
Yes, so I believe the notice was already sent out.
Typically, the way it works is once you waive, we give that jurisdiction 2 weeks to come get you. Now, sometimes there are circumstances that they might want an extension for a day or two at the max 3. But by and large, they're pretty good at getting that jurisdiction to come get you within the next 2 weeks. And then we give you a free ride back to Arizona where you can answer to those charges. Now, like he said, they're willing to set you a bond. Now, it's going to be a high bond, but you got to get there first. And me, I just don't feel comfortable giving you a bond. I don't know you. I know you're telling me it's little bunnies jumping in the woods, but I really just don't know you. All I know is that there's a trail of destruction, and I don't want any more. That's it. Do you understand? Okay. So, I'm sorry, Shreya. I can't.
No worries, I just want to make sure there's nothing else you want the judge to know about bond before we discuss issues.
Now, if you're able to post bond, if you're able to get your family to post a bond in Arizona, then they can release this hold and then we'll let you out. But I don't know if that's going to happen, right? Arizona wants you there before they're going to set you bond, is what they've said. So, but you know, you never know until you try. The worst they can say is no. You have a lawyer, perhaps he can go get you a bond there. Okay.
Thank you, Your Honor.
Good luck, Mr. Campbell.
And there, ladies and gentlemen, was the first ever video for this channel. That's where it all began, and now here we are today. Before we move forward, Barbara, thank you for the $11 total by my count in Super Chat. Appreciate that. Bailey gifted 10 subscriptions and a $1.49 super sticker. Thank you. Michael gifted a sub. Thank you for that. And Ashley, 50 gifted memberships. Thank you so much. You know, one of the things I love about this place is not that you, so much as you support me, as much as you support each other. It's just appreciated all around. So thank you so much. All right, let's move away from the old and into the new. I present to you, ladies and gentlemen, TCF Live version, 5, I think now? We got a new look starting today. I've spent the entire week programming a custom-made Chiron for this show. So we will better be able to present what's going on, what we're watching, any breaking information on the defendants as we see fit. All of that will all be displayed down below. Much cleaner to look at, easier, be better on mobile devices, still great on televisions. We eliminated a lot of the clutter, and this is what we're going to look like moving forward. It will evolve, as things always do, of course, but this is where we start. So let's get this rolling. This is Judge Anzalone. Oh, got to click on the right thing. My normal buttons are a little bit off today until I get everything rolling the way that it should, but there we go.
Mr. Madrid, this is a date and time set for a violation of probation sentencing. And Mr. Madrid, I put you in the breakout room with Miss Underwood. Have you had ample time to speak with Miss Underwood?
Yes, ma'am.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes, I am.
All right. Miss Underwood, you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, I do not, Your Honor. It's a probation
Okay.
violation report.
Okay. All right, but is there anything in there you want to dispute?
No,
Okay, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Madrid?
just that he welcomes the opportunity given by the recommendation to complete the program at Bear River, Your Honor. And we hope a bed can be found very expeditiously.
Okay, Mr. Madrid, is there anything you'd like to say on your own behalf?
No, ma'am.
All right, so Mr. Madrid, the last time you wanted to go to rehab, you said it was the fastest way out of jail. And you knew you were gonna leave, so what are you gonna do this time?
Like I had a little chat with Miss Teskey, and I kind of explained to her how I thought a big part of being able to like suit me would be like somewhere not so close. And no offense on the program in Monroe, but it just wasn't for me. Yeah.
Okay, all right. All right, well, it's sentence of the court that you'll be continued on probation. I will order that you will serve 12 months in Lenawee County Jail. I will give you credit for 238 days, but I will allow you an early release to attend and complete residential treatment at Bear River. So Ms. Teskey will work on that, finding a bed, and when a bed's available. Doesn't usually take very long. When you get released from Bear River, you need to contact Ms. Teskey as soon as you can on your release. Do you understand that?
Yes, ma'am.
Ms. Teskey, anything else you want to add?
I would just like to make sure that we place on the record that probation is continued.
Yep, probation is continued. All right, Mr. Madrid, we're gonna send over to you your notice of right to appellate review. So I'll have you initial and date one copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, all right?
All right.
All right, good luck to you, Mr. Madrid. Thank you.
Thank you, guys. Have a good one.
Ms. Underwood,
Grandma TCF 51 gifted memberships. Thank you so much, Mom. Wahoo sends a membership. Thank you very much. Mom sends another one. 52. Thank you, Mom. Thank you, everybody. See, Michael put in there that he's throwing down based on what everybody else throws down. Currently, it looks like 114, Michael. Thank you all so much, seriously. Let's go to Florida. Wade Mercer, first appearances. Let's give that a look.
Bill.
I don't think it is, Judge.
Who represents Jamie?
Rhonda was her attorney.
Some reason.
There it is.
I wonder why it does that. Is that the system that just takes a minute to cut it down? Or
I think that's what it does. It takes a while for the audio to kick in, and
I don't know if it's somebody's radio out there that's on or what, but so we're here for first appearances. I think we can hear y'all now. It's October 10th, 8/27. Corporal Drown. Sir, good morning. Have you had a chance to play your first appearance video?
Good morning. Yes, sir, we have.
Great. Ladies and gentlemen at the jail, I'm Wade Mercer. I'm the county judge in Jackson County. You're here for first appearances. We have Mr. John McDaniel, Assistant Public Defender. He's your lawyer for today's purposes at the jail. I know that you can see and hear him. I want to make sure you can see and hear the prosecutor, Mr. Mitchell. So I'm going to ask that Mr. Mitchell introduce himself.
Jake Mitchell on behalf of the state.
Thank you. Everything working good audio and video wise, Corporal?
Yes, Your Honor.
Perfect. We have one person that has friends or family here, so we'll take that case first, and that's State versus Tremaine Bell. Bell, good morning. Mr. Bell, your stepmom is in the courtroom. You're here because you've been accused of one count of grand theft, a first-degree felony version of grand theft, based on the amount that you allegedly were involved in taking. You're also accused of a scheme to defraud a financial institution, a second-degree felony, and uttering a forced instrument, a third-degree felony. So you're accused of 3 felonies. Mr. Bell, I looked at your criminal history. I saw 1 prior PTI that you completed, and that's all that you've got on your criminal history. So let me listen to the attorneys, and then I'll be glad to set you a bond. Mr. McDaniel, anything on behalf of Mr. Bell?
No, Your Honor.
Mr. Mitchell?
I think his history is kind of similar to the co-defendant. I mean, he got like a same bond and conditions, so that's what we would request.
Thank you. Mr. McDaniel, does Mr. Bell prefer a cash bond or a surety bond like the co-defendant got?
You're paying 10%. I want to go out.
Your Honor, he just go ahead and ask for a cash bond. All right, so Mr. Bell, Mr. Mitchell, any objection to a cash bond?
No objection to a cash bond.
Mr. Bell, on the grand theft, your cash bond's going to be $5,000 because the allegations is that you and your co-defendant got over $30,000 from the bank. On the scheme to defraud, you're going to have a cash bond of $1,000 and the uttering a forced instrument cash bond of $500. Mr. Bell, your total cash bond is $6,500 cash. You do have a condition to have no contact with that banking institution that you're accused of, allegedly, you're accused of defrauding. And I don't know that I put a condition of no contact on this co-defendant. I probably should have.
Yeah, I was just looking back at that and I didn't see.
Are you related? Are you legally related to Mr. Clopton or just friends?
No, I'm not related to him.
Okay, then there's going to be a condition of no contact between you and Mr. Clopton also. So you can have no contact with him while this case is pending. I need to keep y'all apart, so I don't want y'all getting no trouble together. Mr. Bell,
Yes, sir.
your stepmom's in the courtroom. Let me see if she has any questions. Do you have any questions, ma'am?
Tell him his aunt came.
Okay, let me ask the stepmom. Do you have any questions, ma'am?
No, sir. That cash bond, we'll pay that.
So the cash bond has to be paid at the jail. And the good thing about a cash bond is if you give money to a bondsman in this kind of case and there's restitution owed, the bondsman, that's their services for their fee. A cash bond, the money is held by the clerk's office. If the case is dismissed, let's say it's dismissed, it's returned to whoever posted it. If it's not dismissed, it's taken and applied towards court costs, fines, or restitution. And there's allegedly a lot of restitution. Okay, and your aunt is also in the courtroom now, Mr. Bell. She's just came in. So it's a $6,500 cash bond. Some people prefer a cash bond if there's restitution owed. Mr. Bell, any other questions?
No, sir.
Ms. Williams? Oh, thank you. Mr. Bell, I'm going to ask the jail to give you a notice for your court date. In felony court, November the 4th at 8:30 will be your court date. They'll give you that notice after first appearance. Mr. Bell, I wish you the best, sir.
Yes, sir. Have a nice day.
You too. Thank you for coming.
Your Honor, how do you want to address Mr. Clopton's no contact issue because he didn't have that condition?
Has he posted the bond, Corporal, Mr. Clopton, the co-defendant?
He got out yesterday.
I can't do anything with it then.
Probably address it as arraignment.
When it comes to felony court, y'all can ask Judge Garcia to add that. I should have done it yesterday. I normally do unless they're legally related or I think they're just friends as far as it appears. That's it for the people that have friends or family here, Mr. McDaniel. So we'll go back to the top of the docket. That's Gavin Brown. Mr. Brown, good morning. Mr. Brown, you're here for first appearance accused of 1 count of aggravated assault and 1 count of improper exhibition of a firearm. Mr. Brown, there is probable cause for the charge. However, there's not a significant amount of evidence in excess of probable cause. What that means, Mr. Brown, is one of the factors I have to look at is evidence of guilt. And the evidence of this guilt in this case is someone says you pointed the gun at them. I'm not even clear if the officer talked to the alleged victim or just talked to the alleged victim's parents. It looks like there's one point after he talked to the parent, he went and talked to the alleged victim. So it does appear at some point they actually talked to the person who said this happened. Let me see if the attorneys have any additional information, Mr. Brown, and we'll go from there. Mr. McDaniel?
No, Your Honor.
Mr. Mitchell?
Just a moment. Let me see.
Mr. Brown, how old are you?
I'm 18, sir.
Are you in school?
No, sir. I dropped out, but I'm planning to go back and get my GED in Mariana.
You live in Graceville?
Yes, sir.
You live in with anyone?
I've been staying with my baby mama lately, but no, not for real.
Not for real.
Oh,
Okay.
no, sir. Like I haven't like been having like a place to stay. I just been staying with my baby mama.
How long has it been since you've been out of school, Mr. Brown?
I think I dropped out last year, sir.
So my question really is, if you're not in school, are you working, or how you providing for yourself?
Yes, sir. I got a job. It's like a under the table job. I like going clean trailers out for somebody in Graceville.
Is that pretty regular, pretty consistent work?
Yes, sir. I at least go like 3 times a week.
Okay. Mr. Mitchell?
I think the only condition we would request from the court is that, I know he's 18, but obviously no possession of any firearms.
Mr. McDaniel, anything else?
Give me 1 second.
I can. I was about to say, I think that's already a condition.
So at 18, he legally, I know he can't own a handgun.
Yeah.
Can he possess a handgun legally? I don't know. I think he can possess a long gun for hunting purposes.
I think nonetheless, that's would be our condition, well, our request to the court right there.
Thank you. Mr. McDaniel, do you have anything else to add?
I don't have anything else, Your Honor.
Mr. Brown, if you had a full-time job or a full-time student, I would even consider a conditional release, but I'm not going to do that given your work situation. I'm not crazy about the amount of evidence in this complaint. Someone says you pointed a gun at them. I don't know if you did or not, but there's not a lot of evidence. There's just not a lot there. What I'm going to do is I'm going to set you a bond of $2,500 cash or surety. You're going to have a condition, no contact with the alleged victim, and you're going to have a condition, you do not possess any firearms while the case is pending. You cannot have access to firearms. $2,500 cash or surety means you can go through a bondsman. Mr. Brown, if you go through a bondsman and they charge you 10%, it would cost you $250 to get out of jail. Mr. Brown, you'll use the phone in just a few minutes, sir, to try to post a bond. Just stay away from the alleged victim and no firearms. Mr. Brown, do you have any questions?
No, sir.
Wish you the best, sir.
Is that for each count or the total?
I'm sorry. Let me clarify that. No, it wouldn't be for each count because one's a felony and one's a misdemeanor. So let's do this. My intent was to get around 250. So let's go 1,500 on the ag assault, 1,000 on the improper exhibition, total 2,500.
Okay.
Then that gets us to Christine Mears. Please give him a court date, Corporal Mr. Brown, the same court date as Mr. Bell.
Yes, sir.
Ms. Mears, good morning. Ms. Mears, you're here because you've been accused of violating the terms of your state probation. Ms. Mears, there's a no bond warrant issued in your case, ma'am. I want to get you a lawyer appointed today and get you arraigned if you want a lawyer appointed. Ms. Mears, would you like to have an attorney appointed to represent you?
Permission to speak, sir.
Let me get you appointed a lawyer, and then we'll see if you have any questions in just a second. No, hang on, wait.
I have an attorney.
I'll give you a chance to ask questions, but I need to get you arraigned first. So the first step is, do you want an attorney appointed to represent you, ma'am?
I have an attorney on contingency.
Okay, they have not filed a notice of appearance. Do you want me to appoint someone for you today or not?
Is it okay if I call her to file?
You certainly can do that. Okay, so I'm not going to appoint you to the public defender's office at this time because you're not asking for them. Ms. Mears, now do you have any questions?
Sir, can I just say something?
You have a question, Ms. Mears. I'm glad to try to answer your questions. I can't talk about your case, but if you have a question, I'll try to answer it.
I would like to know if I could get in touch with my attorney that I have on contingency for her to, and if I could have.
Yes, already used the phone.
You will use the phone in a few minutes to call whoever you wish, Ms. Mears. But I'm not appointing you a lawyer this morning because you're not asking for one. Do you have any other questions?
No, sir.
All right, ma'am. Wish you the best. To show that she's not been appointed to the public defender's office, please. So they need to go through that process again.
You want to get like a bring back date for her?
We're going to put her on the same docket, the VOP docket. which would be November the 6th at 8:30. And the last case I have is Jaron Miller. Mr. Miller, good morning. Mr. Miller, you're brought back up to see where we stand on the transport to the state of Alabama. This is unusual. Usually Alabama picks people up really quickly, but this is not a specific county that wants you. This is the Alabama Department of Corrections, apparently. I was advised this morning from Mr. Goodson that there's been very little information or feedback back from them on the transport date. Is that right, Corporal?
Yes, Your Honor, I've contacted them numerous times through teletype and phone, and we've yet to get a response.
Okay. So, Mr. Miller, under Florida law, on that 30 days started the day you signed that waiver. And on the 30th day, when the 30 days expires, you will be released, period. If they call the day before and they say, we're going to be there tomorrow, and it's after the 30 days expires, you're released, you're out. And that warrant in the Jackson County system shows that it's served. So you've heard what I've heard. It's very unusual. I'm going to ask the corporal in the jail to keep trying to contact them, let them know the release date ahead of time, and let them know you're walking out that door if they're not here to pick you up before that morning, whatever the date is. Mr. Miller, do you have any questions?
No, sir.
All right. Wish you the best, sir.
Yes, sir. Thank you.
Yes, sir. Mr. Bell, I think the family member came back in. You have a question, ma'am?
Going to a bail bond.
I don't necessarily have a problem with that. The problem is he's not there anymore. And there's advantages and disadvantages to that. And he's the one that chose the cash bond. So Mr. McDaniel, the family for Mr. Bell is saying they would prefer a surety bond. I don't know if you talked to him about that. The difference is, do you want to bring him back in, or do you feel confident he wants a cash bond?
Well, he would go either way that probably the family would want, Your Honor. I told him the difference of it, and the surety bond money would be disappeared. You'll never see it again. There is a chance that you can get the money back, or at the very least, it's going to go toward anything that might be owed on the case. I don't think he had a major way one way or the other. So Corporal, just Mr. Mitchell, objection to that option?
No.
So Corporal, his options for the bond on Mr. Bell will be the $6,500 cash or $65,000 surety. So you can go through a surety bond. Let's say a bondsman charges them $4,000. Let's say they say you don't have to come up with all $6,500. We'll take $4,000. They pay them $4,000. That $4,000 is gone. It doesn't go to the alleged victim. It doesn't go to his court costs and fines. And if the case is dismissed, it's not returned to whoever posted it. Understand that? Okay. All right. So he has that option. Okay.
Okay.
So, yes, ma'am. Mr. McDaniel, that's everything I had on my list. Anything else from the public defender's office?
Nothing else, Your Honor.
Thank you. Corporal, anything else from the jail?
No, Your Honor.
And Mr. Mitchell from the state?
It's just one thing, but it can be off record and off YouTube.
All right. So, ladies and gentlemen, that concludes.
Well, all right. Don't share with us then the things that we would really want to hear. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Friday. Thank you to everybody for your generosity so far this morning. It's been amazing. You guys are always amazing, but you know, I appreciate it, and you just need to know that. You need to keep hearing that because it's real, and you guys are the best. Let's go to Ohio. Judge Vincent Collada, I believe, is about to do a sentencing. So let's see what that's all about.
Yes. She was last before the court where she entered a plea of guilty to one count of trafficking in drugs, felony of the 5th degree, another count of trafficking in cocaine, felony of the 5th degree, possession of cocaine, felony of the 3rd degree, and receiving proceeds subject to forfeiture, of felony of the 5th degree. At that time that the plea was entered, the court ordered a pre-sentence investigation along with a drug and alcohol evaluation, a psychological evaluation. Those having been accomplished, we are here today for sentencing.
Thank you. Any reason not to go forward with sentencing? Mr. Martinez?
Good morning, Your Honor. Hector Martinez here on behalf of Ms. Herzenstein. We have reviewed the pre-sentence report. It seems to be accurate. There's no additions, deletions, or corrections from our end, and we're ready to proceed with sentencing.
Very well. Is there anything you would like to say at this time on behalf of your client, or anything you'd like to present for the court's consideration?
Yes, Your Honor. I would like to speak on Ms. Herzenstein's behalf. Initially, we have a few people who would like to address the court on her behalf prior to my presentation, so I'd ask them to introduce themselves one by one and speak to the board.
You have a microphone?
Yeah, thank you.
Whoever it is that would like to speak at this time, I'm going to have you, we'll hand you a microphone to speak into. Just state your name, spell your last name for the court report, and then take your time and say whatever you'd like me to know. I probably could just, I don't know if you need to hold it or set it there, whatever works.
Test.
You just hold it down lower and it'll pick it up.
Okay. Amy Herzenstein, I'm Zoe's mother.
Okay?
Heraclitus, a Greek philosopher, once said, "No man ever steps into the same river twice, for it is not the same river, and he's not the same man." We are forever changing, and the river is also forever changing. Before the accident, Zoe had called me one day to share with me her thoughts about her goals in life. Sorry, let me just take a breath.
Take your time.
Since Zoe had moved out of our home, she had worked a number of jobs at the same time to support herself. She did not ask for assistance. She was independent and capable. At this particular juncture, she had given great thought to her current way of life and the changes that she wanted to make for a productive and meaningful future for herself. She shared that she was tired of the late hours of bartending and other aspects of the job that she felt she had outgrown. She had accepted a job at a Willoughby canning company that had regular business hours and also had tuition assistance for attending college, among other benefits. As she laid out her reasoning and her proactive actions, I felt so proud of her introspection and, more importantly, her actions. She was telling me all of this after the fact. She had the confidence and the strength to act on her beliefs. Also, before the accident, Zoe had invited us to hear her sing with her band. What a phenomenal night that was. It was a large band with all of the pieces. The most impressive piece, in my opinion, was Zoe's incredible voice. It was a magical night indeed, watching my talented daughter shine her light. Zoe played many instruments herself. She was first chair in high school for flute. Not only did Zoe play instruments, but she wrote her own songs. She was truly gifted. But what made her gifts special was her inner light that shined through her music. And yes, you could say I'm biased, but everyone who heard her would comment on this. Zoe was following her passions while practically working to support herself. She was growing and evolving. I was so very proud of her. On March 14, 2020, Zoe's car was hit head-on by a drunk driver driving the wrong way on the freeway. The two cars of Zoe's friends that she was following were able to see the car coming at them and swerved out of the way. Zoe had no way of seeing the car that struck her at full speed. This horrific accident took the life of her best friend and her best friend's boyfriend, who was also Zoe's good friend, and it injured another friend who survived the accident. The surgeons and the police spoke with us and tried to prepare us. No one thought that Zoe would survive, but Zoe's spirit showed us all. She came out of her coma to discover she had lost her friends and that she had lost her limb and her body as she had known it before the accident. She set herself intermittent goals, and we celebrated each one: to drink water or thin liquid, to get out of bed using the Hoyer lift while she had a fixator bar protruding from her pelvis, to take her first steps with her prosthetic, and many more. There are different ways to approach and deal with our lives. We have various choices to make. We can give up, we can live in victimhood, or we can choose to grow and evolve using our challenges and traumas as teachers and implements of change. Sounds easier than it is. Zoe continually chooses to grow and move past of what was to living in the what is, living in the now. Her doctors told us she would live the rest of her life in pain. She is in a lot of pain daily. To her, most likely, it is from minute to minute, hourly. Pain is horrible to live with. Zoe had spinal surgery, rib fractures, pelvis surgery with a fixator bar attached to her for many months, femur and fibular bones in both legs, a liver laceration, bruised spleen, and a traumatic brain injury. She was on a ventilator and had a feeding tube. The surgeons tried to save her leg by using a vein from her arms and her legs to improve circulation. Unfortunately, the amputation proved necessary. Her recovery was a long one and is still ongoing. However, Zoe's approach to healing is so impressive. I don't know anyone who would be handling it like she is. I've said this all along. She doesn't complain. She does what needs to be done. Instead of performing, Zoe reinvented herself as a concert photographer. She takes the most fabulous photos and captures incredible moments. Her name, Zoe, means life. And that is what she's doing, living. She finds ways to make her life work. All of this is leading up to this very moment. It goes without saying that I'm beyond disappointed that Zoe went the route she did. The fact that we are here today because of this is very hard to accept. Living with insurmountable, endless pain is a very hard way to live and navigate life. Her doctors talked to us extensively about this. The impact her body endured from the accident was monumental. Zoe has accepted responsibility and is making strong efforts to straighten out her life. She has been in therapy, attending IOP, studying psychology, all the while working with how to live with pain and continual adjustments with her prosthetic. When Zoe was in school, she volunteered at the Friendship Circle, working with children on the autism spectrum. She would sit next to a boy on the bus who was being teased and didn't have friends. Her interest in majoring in psychology is very fitting. She is on a trajectory to be a contributing member of society. What a phenomenal healer she will be with the background of all that she is overcoming. Growth certainly is not linear. These were not the zigs and zags that a parent potentially foresees. But it's where we are now, a pivotal moment in time. Zoe is showing evidence of introspection, acceptance of responsibility, and productive actions and behavior. She is showing the willingness to make the changes necessary and to make things right. I'm so very proud of her ability to deal with everything she has experienced from the accident on to this day. She isn't playing the blame game. She is showing up, taking responsibility, healing, and working productively. This situation has shaken Zoe to her core. She is on a course of healing, correction, and growth. It is again evidence that no man ever steps into the same river twice, for it's not the same river, and he's not the same man. Thank you.
Thank you.
Let's let David go first.
David Drew, I'm Zoe's partner. I'll be reading from my phone. I've only known Zoe for about 3 years. It's hard for me to tell you what the effects of her accident were firsthand. I will say that I've seen it affect everything from jobs like being a barista in a fast-paced environment, her photography, her singing, even just going for a walk in the woods, everything. I can tell you, however, about the person she is today. When I met Zoe, the first thing that struck me about her was this. Here was a person who had every reason to give up, to let the sadness win, and she does not. She finds life's small miracles and celebrates them. It was such a beautiful thing to witness and a trait that I've tried to adopt more myself. The longer I got to know her and the closer we became, I realized it's even bigger than that. She takes every opportunity to help those around her. She lifts people up. I've literally seen her take food from her own refrigerator and give it to her friends because she didn't have money to buy them groceries, but she wanted to make sure they were cared for and got to eat. On days that we're together that I have to go to work, she gets out of bed at 4:30 in the morning with me to cook me breakfast and make sure I have a lunch and maybe a cup of coffee for the ride in, things that I don't even do for myself. Since the incidents that led to this court case, I've watched her strive to change her life with the same drive and tenacity. She has accepted responsibility for her wrongs. She attends meetings nearly every day. She shifted her focus to things like physical therapy so she can learn to walk again. She's become a talented gardener, adorning both our homes with beautiful houseplants and herbs that we use to cook every day. She also started attending college courses for a degree in psychology. All of these things are so that she can become the best version of herself, and she works tirelessly at them. She wants to not only better herself, but also to be someone everyone around her can count on. Thank you.
Thank you, sir. Mr. Martinez?
My name is Jonathan Herzenstein. I am Zoe's father. And today is a little more emotional for me than I thought it would be. And everything that Amy has said and Dave has said is very hard for me to elaborate on. I did write a letter to the court reflecting on Zoe's life, what it's been like, what she was like as a child. She was always, she could sing before she could talk, and she's always been so full of life. And the events that occurred when she was hit by the drunk driver, while it changed all of our lives, it did not deviate Zoe from her path of living. And she never uses the accident as an excuse for anything that she could use it for. She's very, very impressive as a human being. Each of us errs in life. I believe there's redemption for everyone. Zoe's done everything in the world that she can to better herself and better her life. From enrolling in college, from going to IOP religiously, to changing the people that she chooses to keep company with. Her life has been a miracle to me. Her survival has been a miracle. And I hope that, I know that she's learned from this, and I hope that moving forward that she'll be treated fairly.
Thank you, sir. Anyone else, Mr. Martinez?
All right. I'm going to have Zoe address the court, then I'll wrap things up.
Ms. Herzenstein, you have the right to address the court before your sentence. You can say anything you like. Is there anything you care for me to consider at this time? Anything you want to say?
Oh, yes, sorry. Your Honor, they're basically what my parents and my partner just said. I have no excuse to give you. I could give you any of the things they said, but I knew what I was doing was wrong, and I did it anyway. So I am deeply sorry for my actions. I am very thankful that it happened though, because without that happening, I don't know if I would have had as much of a drive to change my life and go back to school, take my physical therapy as seriously, and to work on myself as a person. So although most people probably wouldn't need what happened to happen to do that, for me, it's a really great way for me to never want to do those things again. And I'm grateful that I'm able to still be here today and to say this in front of you.
Thank you. Mr. Martinez.
Thank you, Your Honor. I'm going to expand on what Zoe just said, that she's thankful that these events happened. And, you know, I can sit here and criticize how this all, how this winds up to us being in this particular spot, that her friends who she was partying with go to the Lake Harney Narcotics. They end up purchasing drugs from her and turn that into the Lake Harney Narcotics. Then she is ensnared in this. But as Zoe said, she was backsliding, I think. Well, we know that because the accident happened in March of 2020. She really attacked her rehabilitation with great fervor and zest thereafter. And then probably the pain got to the point where she said, I can start using these drugs to mask that pain. And she has indescribable pain, physically and mentally. None of us in this court can imagine waking up from a coma and feeling what she felt, losing a limb, losing your best friend, losing your best friend's boyfriend, and then thereafter just being in this incredible pain every day. And what was she using? She was using cocaine. She was using ketamine. Ketamine masks that pain. It's used as an anesthetic for animals. I think Zoe felt that that was masking her pain. It was masking her emotional distress from the accident. And as she is telling you today, she is thankful that this happened because it has led her to a place where she can reset her recovery. She went into Signature Health. She enrolled into the treatment program. She completed the treatment program. She's been going to meetings, as David had indicated. I've talked to her about attending even more meetings, and she's in accordance and in agreement with that. She's working on her mental health. As we discussed earlier, she needs to get a psychologist who really she can connect with and work on her issues. I think what's also been kind of glossed over here is that she did suffer a traumatic brain injury in this accident. And I think that affects her decision-making, impulse control. She has an appointment, obviously, with her neurologist in December, which I think is very important that she keep. Zoe and I have talked about her rehabilitation, that she needs to get in there and do her physical therapy because she has a singular goal, which is to get the prosthetic leg and to walk again. And she needs to continue to work every day towards that goal. She needs to get in that physical therapy. I know her parents are encouraging her. We're encouraging her. She needs to have that zest that she has for life and for helping her friends and for dealing with her drug addiction. And also, she needs to push forward with that physical rehabilitation. And Rick and I are both confident that she's going to do that, and we're going to follow her progress. Now, I can belabor going through these sentencing factors here, Your Honor. Number one, she has tremendous support from her family. She has tremendous support from her friends. The public does not need protection from Zoe. It does not. Zoe needs help. We appreciate Ms. Henley's pre-sentence report. We appreciate Ms. Friend's comprehensive assessment, which we agree with 100%, that she should complete her aftercare, that she should immerse herself in mental health counseling, that she should do all those things that Ms. Friend asked her to do, that she should go to 12-step meetings at least 3 to 5 times per week. One doctor, one dentist, we get all that. She's prescribed some medications. She will be 100% compliant with her medications. I also want to emphasize the fact that Zoe did lose her ability to sing at the level that she sang prior to this accident. But I love what her mom said, that Zoe has reinvented herself. She loves music. Okay, what can I do to continue that passion for music? Well, she's a photographer. She goes to the concert, she takes tremendous photographs of the shows. That's a passion of hers. She should continue that. We want her to continue that. She's willing to do whatever community service this court would order. I think Zoe is capable of performing community work service for this court. And I know she thinks she's capable of doing that. With regard to the presumption in this case of any prison time, it's our position that that has been rebutted. Zoe has no prior juvenile history. She has no prior criminal history. These are circumstances that are not likely to recur. She shows genuine remorse for what happened. She has a drug and alcohol or drug addiction. She acknowledges that drug addiction. She's taken steps to treat that drug addiction. She hits all the sentencing factors, Your Honor, to overcome that presumption. So it's our position that Zoe is an excellent candidate for community control sanctions, that this court would promote, would punish her by, well, she's being punished. She's getting a felony conviction. She already served 3 days in jail. She has embarrassed her family. She's embarrassed her attorney, her other attorney. She feels that, but she needs to move forward in this. The punishment has been imposed. The public does not need protection from Zoe in this case. She's not going to do this again. She's not a danger to this community. And we need to promote her effective rehabilitation. She can do that. She's already doing that. I am confident that this court's adult probation department will give her whatever other support she needs to do that. And we would ask the court to take all that into consideration in fashioning an appropriate sentence of community control sanctions. Thank you.
Thank you. Anything else on behalf of the defense?
No, Your Honor.
Okay.
Thank you.
Ms. Mulligan for the state.
Your Honor, the state will recommend that she be given a chance at community control.
This court has reviewed the pre-sentence report and investigation, psychological evaluation. I've reviewed the sentencing memorandum that was found in this case, all the attachments there too, and the letters. I have considered the facts and circumstances of the offenses involved, the nature of the offenses involved, and I have considered everything that's been said here today by her parents, her partner, counsel, defendant herself, as well as the prosecutor's recommendation. I consider all of this in light of the purposes and principles of felony sentencing, which are set forth in 29-2911 of the revised code. For the factors in 29-29-12, I don't find any factors present making the offense more or less serious. For recidivism factors, no factors are present indicating recidivism is more likely. As for the factors indicating it's less likely, the court notes the defendant doesn't have any prior delinquency adjudications, no convictions as an adult, led a law-abiding life for a significant number of years, appears to show genuine remorse. There is a presumption for prison in this case. Despite that, the court will give the defendant a chance on community control sanctions, finding that prison is not consistent with the purposes and principles of sentencing. The defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. As part of her sanctions, there are going to be some consequences, though. This is pretty serious what happened here. I mean, you were multiple sales at large amounts. The typical deals that we deal with here in Lake County are much smaller amounts. You said you were selling just enough to be able to support your habit. Well, you were selling $600 and $450 and $450. That's well more than we see here in Lake County normally. And a person with those transactions and those and that conduct and the amount of times if they don't go to prison, which happens frequently, they're doing significant jail time. I'm going to order as conditions of your community control sanctions that you serve 30 days in the Lake County Jail, which is well less than what most people would serve in these circumstances. You have 3 days of credit. Upon your release from the jail, I'm going to order that you serve 60 days of house arrest with GPS monitoring through the jail diversion program, which then the probation pays for that. It's not self-pay. I will allow you to be released to attend medical appointments, probation requirements and obligations, Are you working right now?
I have a job doing handicap services.
I can't understand.
I have a job that helps with handicap patients or festival attenders at concerts and events, but it's only temporary. It's like a contract job.
Well, I'll let you attend. If there's a job that you have, I'll let you do that. I mean, if a festival comes up and you're going to do that, I'll allow you to do that, but you need the probation know about that. It's not going to be a regular thing, doesn't sound like. So if something like that happens, I'll allow you to attend that, but probation needs to be advised prior to that.
Thank you.
So release for medical appointments, which includes, mental health as well, obviously. And to do whatever obligation, to accomplish whatever obligations are required as a result of probation. Further conditions, you're not to use any drugs or alcohol, and that includes no marijuana. You're to submit random urine screens. They must be negative. Positive screens, a violation. Can't tamper with the urine screens, substitute someone else's, do anything like that. You're to attend 3 AA meetings a week and have a sponsor. I'm going to order that you perform 40 hours of community service. I'm sorry, I meant it was 30 hours. 30 hours of community service. I'm not going to order any specific requirement about employment. You want to get employment, that's fine. I am going to say that you're not to be employed at any bars or taverns. So if you are going to work, it's not going to be there. You're to take all your medications as prescribed. I want you to complete the aftercare program that you're currently in with Signature Health. Continue with your mental health medication management through Signature Health.
Your Honor, she completed that aftercare program already, is my understanding.
Okay, well, if it's completed, then, all right. If it's completed, then fine. If not, I'm going to put that in there, and if it's completed, then she's satisfied that.
Thank you.
What is the growth therapy that you were doing? Are you still doing that?
No, I'm looking for a new counselor. I wasn't receiving the level of care that I would like.
What is that?
I would like a psychologist, somebody that's well.
No. What is the growth therapy?
Oh, it's an online therapy. It's a video chat therapy.
Well, you need to be obtaining psychological counseling.
Yes.
You need to do that immediately. I don't want gaps. I don't want you to be doing it and then not be happy, so you stop and look for someone else. You can look for someone else if you want, but you're going to continue to stay in it until you find the other person, so you can transition right into that. I don't want it stopping and then there being nothing going on.
I have an appointment on the 21st, I believe. You need a referral from a doctor to get a psychologist referral through Metro Health. So I have an appointment to get a referral for that.
Right, well, you need to start that up immediately. That's mental health counseling, psychological counseling, right?
So the 21st you would be in jail.
I want you to comply with all recommendations given at your upcoming neurological appointment. And you should utilize case management services through Signature Health to assist you with community resources as needed. Prepare court costs and supervision fees. There's a mandatory fine required to be imposed on a lesser included offense of count 8. I'll impose the minimum mandatory fine of $5,000.
Judge, we're going to file an affidavit of indigency. Would we be permitted till the end of the day to do that? We neglected to do that.
How is that? We've got two private attorneys here.
Well, it didn't come from her. She did not. She has family that retained us. She makes, I think, about $1,300 a month.
Because I mean, if something's filed before the sentencing entry is filed, and that's not going to get signed today, I can tell you that. Then
we'll get it
I'll
filed
consider
today,
that.
Judge.
Okay. I'm going to order the four.
Pardon?
I'm waiting. If you need to talk to your attorney, go ahead.
Am I able to request time to just be able to get my affairs and home in order so that I'm able to make sure my cat has someone to take care of him, someone has a key to my house and stuff like that?
We can ask him, but it's unlikely he's going to do that. You're going to probably have to rely on your family to do that. Okay.
What's that?
Judge.
I mean, you don't have to tell me what she said. I mean, it's up to.
Yeah, she was going to ask if the court would consider giving her a few days to report.
Well, we're not to that. Let me finish my sentence.
All right, thank you, Your Honor.
I'm going to order the forfeiture of $1,045 regarding count 11. Is that the correct amount?
Yes, Your Honor.
I'll dismiss the balance of the indictment. Stanley, is there anything else I should be considering?
No, Your Honor, thank you.
Ms. Herzenstein, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you if you fail to comply with any of the conditions of your community control sanctions, any of the rules of probation which will be gone over with you, if you leave the state of Ohio without permission from this court, or if you commit any new offenses while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 12 months on count 3, 12 months on count 6, 36 months on the lesser included offense of count 8, and 12 months on count 11. Those would all be served consecutive to each other for an overall prison term of 72 months or 6 years in prison. You understand that?
Yes, Your Honor.
All right, Mr. Perez, you want to be heard on something, Amanda?
Judge, two things. Appreciate you allowing us to file the affidavit of indigency. She would ask if you would give her a few days before she has to report to take care of some things with her home and situations that she will need in the jail. The last time she was in jail for those 3 days, they would not let her take her wheelchair in. They gave her a manual wheelchair that was really not wide enough for her to sit in. It was difficult for her. We would ask if the court would allow, and I know this is up to the jail, if they would search her equipment, allow her to take that equipment in. Also, she needed diapers and things when she was in there that she wasn't getting the last time was made very difficult. So, I mean, I can approach some of these things with the sheriff. I don't know if you could do anything to assist in that regard, but
That's up to the sheriff. I don't interfere with their security measures that they get involved with. In regards to reporting, this has been set for some time, and she was a presumption for prison in this case. Whatever matters needed to be taken care of should have been taken care of prior to coming in the court here today. So that request is denied. Is there anything else for the record?
No, Your Honor.
Mr. Martinez, Mr. Perez?
no, Your Honor.
No, Your Honor.
Okay, that was simultaneously intriguing and confusing as all get out. Thank you, Lindsay, for making sense of it all. According to Lindsay, the traffic accident was a separate incident. They were all actually victims, and this was a sentencing for drugs. But in the beginning, it sounded to me like she killed 2 people, and even before that, I thought the victim was the one that lost the limb, which is why I'd put on the chyron that the victim had lost a limb, because I thought that's what it was, and then it became clear that it wasn't. And yeah, super confusing on that one. So thank you, Lindsay, for helping us make a little bit of sense out of all of this, because it was messy. And Barbara put that he's now on the Judge Stevens list. So why not? Let's just go to Judge Stevens then.
2025 in Jefferson County, Texas, it is alleged he recklessly caused bodily injury to a child 14 years of age or younger. And that carries with it, if convicted, no less than 180 days up to 2 years in the state jail and a fine up to $10,000. Do you understand the punishment range you're facing? Yes, ma'am. Okay. All right. Let's see. To the hearing type announcement. What's this?
Yeah, no, well, this is more of a, we're here to talk about the bond condition about contact with the complaining witnesses. As a last condition.
Okay, she was indicted back in July. Okay. Go ahead.
Sorry, Judge, I just got.
Yes, sir.
I haven't had a chance to make copies of these, but she just presented them to me. These are in additional letters. Did you want to see them first? For what we're doing?
What do they say? What are you asking for?
Judge,
Today.
the child involved, Ladarian.
Yeah.
He's a special needs child, and I mean, the allegations against Ms. LeBeau are that there was injury to a child, but apparently her son is uncontrollable from the school's point of view. I think the grandmother is also, she's the one that's been taking care of him and is unable to control him now. In fact, she's the one that urged us to have the hearing this morning to try to figure out some way, somehow, that either Miss LeBeau or somebody can have, access to or possession of the child, so that for control purposes, because apparently he's not the ideal student, and that's we get provided some disciplinary records from Roy Guest, which includes some violent episodes. I had those years. And then a letter from the principal saying that stability in the home is really required. And also a letter from I believe she's a clerk, that's, saying that the child has been unruly at best, and they need help. They need help to come in and help control him. Someone that can actually help administer his medications, help control him, help deal with him, that kind of thing. So, and I have apparently, I think it was just the other day, another episode with, he's bitten the police officer at the school. I think after a quick reading of this letter, I think this is a quick account of what happened the other day, where he got into a tip with the officer Thoreau, and then some other letters in support of Ms. LeBeau either getting the kid back, so that way someone can manage the child. This is admittedly a unique situation, where there's a mom and a child versus 2 adults. That's someone that's called up ladies. That way?
Yes.
Okay.
Someone will deliver the full amount of the bond in cash.
While Judge reviews document after document here, I just wanted to again thank everybody for all your support and generosity, not only today, but throughout the past year. This has been one of the best years for me, and I've really enjoyed it, and so happy that we've been able to develop what we've developed here. So thank you again.
Yes. Child, big thing, if you didn't talk to me, I most of this. The action. That's what I said. That was in the file. Except, I said, no, that's not. What do you want to say? I'm gonna try to show you, know.
Spots enough. All right. Y'all looked at this more than I have. And here's the question on that. Is this okay. Restate your, on behalf of the defendant who's present, Mr. Turk, tell me what the point is you're addressing here, so I can clear clearly.
Judge, we're asking at this point, I guess that particular bond condition where she can't have contact with her son to be lifted. So that way, because my understanding from what I've read and the letters I've gotten and the disciplinary, she is about the only person that can control her son. And I think if need be, the grandmother who's been watching the child is here to tell, can say the same thing, that he's difficult to manage. And so in the unique request, in the circumstances, they're worried about him running away, hurting others, hurting himself, those kind of things. I understand the context of which we're talking about this as well, and understand the uniqueness of what the request is. I know the state's going to come back with their side, but Ms. LeBeau is requesting either she needs help, the child needs help with life, and someone to supervise him. And the grandmother is kind of at wit's end apparently and unable to control
But
him.
you're saying she's the answer, the defendant.
Yes, at this point, that's what I understood.
All right, couple of things. Number one, she admits she whipped him and she states a belt only. Even if that were true, which the marks are on here, how is that not injury to a child? How is that not what she admitted to is the crime? It's just what happens? The issue of whether there was an extension cord or a belt, whatever it is, each of those are capable of causing injuries to a child. Things are different from when we were young. It's evolved. The discipline is different now. But she's charged with injury to a child. She's admitted doing that in this probable cause affidavit. Why is it the child's fault, not hers? That's what we're talking. The child wasn't indicted. She was. Now, in all due respect, I think you're correct of your concern with the child as well as what you're hinting at, because you're a good man. Man, you're both good men. We've got a problem here with the defendant parent who admits to whipping him with a belt, and then there are the opinions of others of what could have been used, but whatever was used, it rendered injuries to a child, and that's the crime. And that's a primary issue here. The other one is also always an issue with courts when we deal with children. What's in the best interests of the child? And that's going to be the question in the disposition of how we do this, because the court's going to be sensitive to not only dealing with the rights of this defendant, which are sacred, but the best interests of a child, which is also sacred law under American jurisprudence, how these two interests can work to keep, if possible, a family in a unit with parent and child. And that's not going to be an easy one here, because the discipline, children should be disciplined when necessary. But there's a difference in the way discipline is lawful now as it was when I was young. And the whipping with items which cause injury to a child meet the definition of assault. And you can't say, well, it was for discipline purposes. I have a right to discipline a child. Yeah, but the law, good luck with trying to figure out where the law ends with a parent's rights and then other people's responsibilities. It's important children are disciplined, but it's probably under the law not a good idea to be whipping the child that causes the definition of injury to a child, even if it's for disciplinary purposes, because the line on where that may be for discipline purposes and where it becomes illegal because it fits the definition of injury to a child is really not all that clear. But when you have experts here who show child has marks and states he was the grand jury indicted here by striking the child about the head and body with an extension cord. The defense's response is it wasn't an extension cord, it was a belt. That doesn't help. That doesn't change much. The responsibility when you have marks on the child and they're complaining, you got issues. But this is one of these where I believe the family unit, which I hope we can preserve, needs to be treated, not only the defendant's needs, not only the victim's needs, but the defendant's needs as well for more responsible parenting. I'm all for that. Not to get involved in the negotiation process of where this should be, because that's not a judge's position, but in the best interest of justice, that's where I see the concerns that need to be addressed. And I want to see the family stay into a unit. You love your child. I'm sure the child loves you. We don't want to be part of breaking it up, but the discipline, even in the fact that this may be difficult because of the child's special needs, you lose your composure, you can pay a price. Legally and criminally. Children are sometimes you have on a special needs child, you're going to have to go the extra mile to a couple of things: maintain your composure when dealing with the problems, and number two is making a clear determination in your mind what's legal and what's not legal in the matter of discipline. And whipping the child with that, no matter what it is, extension cord, the grand jury says, or belt, you say, the harm is the same. So let's figure that out. But that's what I want. If I was talking to Santa Claus, not to make this, but we've got two issues here: the child's needs, and also it's important to family unit. I don't want to see a family broken up because I sense you care very much for your child. Let's fix this if we can. All right. What's that saying?
Judge, looking at it, when she lost her temper, you could tell she said these injuries were caused because she whipped him while she was mad. We're responsible for the safety of that child. And so we would object to her having access right now, unless there's some type of anger management parenting classes that would be approved by what we normally do in probation to give them custody, something that we can feel like she's had at least
shame
some
on her. If it happens on our watch, my watch here, before we can get this fixed, shame on. If it happened again, shame on me. And I don't like that. I agree with the state. I urge, as a condition of bond here, that you take a parenting class so that it is as soon as possible and complete that, so that information and education that all parents probably could use. It would make them even better as a parent. I don't think that's anything that you should be afraid of, but if you can get that accomplished, and then we have a third party expert come in and meet with you and the child and the parties, the attorneys, and that independent group goes, I think a mistake was made. Parenting is not easy, especially with a special needs child. This lady's intent is to do the right thing, and she's taken classes, and we believe she's learned better methods of dealing with issues that are going to come up again. They always do in the rearing of a child until they become an adult. So I agree. This would make a better family unit anyway, which is what we're supposed to be helping do. How long do those parenting programs?
I don't know. It depends on which one you get into.
I must say, I order them all the time. I just don't really know how long they take. And I think a lot of it is how often you can attend, because I think there has to be X amount of attendance. And sometimes people aren't able to go all the time, and they at work or some other reasons, and then it takes longer than others. But anyway, that's That is, but I agree with you, Mr. Turk. I'd like this family unit put together and not separated. But now's not the safest time based upon the circumstances that we have here. Let's get her into a program as soon as possible to complete it. And the state will use their resources to help the prosecution determine when an independent expert authority can say, we feel like maybe the best interests are served by putting the family back together. Whenever that may be. Because it's not for you or me. I mean, I don't think we're the experts on this when it comes to disciplinary needs and undoing what's happened here. What do you want? It's an announcement today. Just continue it for.
Yes, sir. I think thank you. Reset it. So, I mean, apparently the court's is ordering her to take the parenting class now. Or is it just something?
That's a condition of what your request is. Your request is for her to see the child. Unless that's done, and until that's done, this court does not feel like it's in the best interest of the child for her and the child to be together until she goes through the class that would help change her methodology and discipline.
I think I might have a resolution to this one. If I'll get with Mike.
Okay.
So we can come back and revisit with you.
Okay. Thank you. Please, ma'am, work with Mr. Turk. He's a good man.
Are we doing something?
John Bordash.
Yes.
What are we doing? We reviewing. Let's do a review and. How much time?
2 weeks. Or is that too quick?
3
weeks. I mean,
yes.
I think I've had.
Morning, Jeff.
John Bordash. And we received this information from UT Health. He was admitted to the facility. Is of the opinion that the defendant is currently incompetent to stand trial. You know that. Yes. You heard. Okay. Do we need the defendant out or?
He's gonna have a sheet set.
Oh, okay. Bring him out.
You'll remember when he's out here.
What is so? Meets the criteria of outpatient civil commitment. Okay. What's today's day?
10.
Judge.
You can see in the face of it. Not. Current goes. Their third party with this.
All right, we now call this cause 23 CR 1439, the state of Texas versus John Walter Bardash Jr. That is you, present with Mr. West, your attorney and the state's attorney. We're here on the issue of competency. The defendant had been admitted to the University of Texas Health Science Center at Houston for evaluation on June 24th of this year. And this was pursuant to Article 46B.073 of the Texas Code of Criminal Procedure. And after a period of observation and treatment, the defendant has been evaluated for competency by the University of Texas Health Center. And it is the opinion of the evaluation that the defendant is currently incompetent to stand trial and is not likely to be restored to competency within the timeframe statutorily available. It further states here in the documents from the UT Health Science Center, which is consisting of 20 pages. We are calling this Court's Exhibit Number 1 on this date. The defendant meets criteria for outpatient civil commitment as of the date of this letter. 2 certificates of medical examination have been submitted to this court along with the competency report. And it goes on to state if the court chooses to return the defendant for further proceedings, then it respectfully requests the court that the sheriff or your county transport the defendant to your court promptly in accordance with Article 46B.082 subpart B of the Texas Code of Criminal Procedure. Okay, so that's the issue. Everybody has read this, and Court's Exhibit 1 is part of the record, and it will
Have we done that bit, we're supposed to put on when we first open this up?
be made part of the record
No, there's not longer.
without objection.
There's a little check. Tell me if it's out, I haven't done that before. Where is that? It's an annual form to file and they don't take it. Well, they say you pull up the phone, right at the top, right as this really like the program. Yeah, now there's a, we get a case over here. Okay, forms.
Okay. So what do the parties say? Any objections here to this these findings, state?
No objections from
And
the state.
defense? All right, what's our plan? What a outpatient program are we talking about?
I'm talking about any program, I don't know.
Well, it says that's what he's there for. I mean, we're not going, it says he's incompetent, and there's going to be a program that Mr. Bordash is going to be required to attend to help him with his mental health needs. What do y'all, have you had a chance to review this yet? Thoroughly?
Yeah.
What is it? What do you think are in his best interests and the interest of the general public in the outpatient? It says outpatient. What's the plan? I don't have one.
May I have a moment to confer with Mr. West?
Just a second. Do you have y'all talked to him? Have you and he talked at all of this? Y'all haven't? Okay, y'all talk.
Yeah, let's talk real quick.
Okay. While we're doing that, let's go to Kevin Walker. Yeah. It says
So we're going to continue to ride with Judge Stevens here for just a little bit because he has consistent contestants. And honestly, it's a little bit of a quieter morning out there unless you're into landlord-tenant, which we generally aren't. So we'll stick here for just a little while longer.
Okay, 23 CR 2054 is called. You are Kevin Walker. With Mr. Your attorney, and you were charged with operating a motor vehicle with a child passenger under 15 years of age. looks like.
Process.
So this was at about midnight, right? And Gulf in Beaumont, Texas, Gulf and Interstate 10. Police found, I guess, the defendant slumped over the wheel. His car, vehicle was running. Small child in the back seat. Was it his 10-month daughter?
Yeah. Is that battle in the species we found?
What happened on the
0.164.
Oh, okay. Okay. What do we have? Trials?
Yeah, Judge, I'm gonna keep trying to.
But until then,
put it on trial.
all right, it's set for trials.
I'm gonna keep trying to resolve this.
Okay, so,
We said, find out what we gotta do this.
put this fast. This thing was indicted going on 2 years ago.
Yeah, its age is gonna pop up when it's on the trial docket, Judge. You're gonna give it priority for that reason anyway.
Okay, let's go. Let's get this, it's fast tracked. Get onto a trial docket as soon as I would think everybody's ready.
We can't do this.
We will be jealous.
Okay. Oh.
Questions from all.
If 23-41385, the state of Texas versus Orlando Durgan, there's a motion to dismiss before the court. That is being signed on this date.
All right, he might be between contestants now. Let's go back to Ohio and Judge Collada. He has a different sentencing, so let's give that a look. If things are a little more janky today, by the way, apologies. The workflow is different now with the new presentation, so I'm making adjustments on the fly first time through. But let's go to Ohio.
Case 24-CR1186. We're here today for the purposes of a sentencing hearing. The last time we were before this court, the defendant was found guilty by a jury of all 8 counts in the indictment. Today, the state would elect to proceed to sentencing on count 2, felonious assault with a deadly weapon against John Cadis. We would state that counts 1 and 5 merge into count 2. Count 4, felonious assault with a deadly weapon against Nora Stinson. Counts 3 and 6 would merge into count 4. And count 8, failure to stop after an accident, of felony 5. Count 7 would merge into count 8. Thank you.
Thank you. Mr. Martinez, any reason not to go forward with sentencing?
Good morning, Your Honor. Hector Martinez here on behalf of Mr. Setzer. Initially, we would concur with the state's merger position on this case. We have reviewed the pre-sentence report. I was able to review that with Mr. Setzer in the jail, and we are prepared to proceed with sentencing.
Thank you. You answered my first question, then you agree with the merger analysis. Is there anything then you would like to say on behalf of your client?
Yes. Initially, Mr. Setzer would like to address the court.
Mr. Setzer, you have the right to address the court prior to being sentenced. Is there anything you care to say at this time?
I wrote a letter
First and foremost, I'd like to apologize to everybody involved in this accident, mostly to Miss Stetson and her daughter. I truly apologize for what has happened to her and her daughter. If I could change anything that happened to that day, I would do it in a heartbeat. Hope they both get through this very soon, and I hope they find peace. I'd like also to apologize to John as well. I hope he gets through his injuries and someday gets the help that he might need. I see a lot of himself in me. I see a lot of himself in me from 25 to 30 years ago when I was a using addict. Secondly, I'd like to thank you for revoking my bond and sending me to jail. This is, in the past 43 days, this has been a very big eye-opener for me. Has shown me that just how far I've come and grown in my recovery in my life. Sometimes you don't see just how far you've grown until something bad like this has happened. It's shown me some areas of my life where I've become stagnant and complacent. In my life, in my recovery, I would like to explain that part of where I've been complacent was very hard to explain because sometimes I have a hard time finding words. Being in there again. Has shown me that you need a certain mindset and mentality to be in there that I no longer have. There was a CEO, Mr. Dizer, years ago when last time I was there, told me if I didn't like being there, not to do the stupid things that will put me there, and I have not done that. In my recovery, my mindset and mentality today is not to get into trouble and go to jail or do anything that will put me there. Or if it means me losing my driver's license, I don't do it. If it means me paying fines, I don't do it. If it means me running to the cops and getting me in trouble, I don't do it. My mindset today is getting back to the community that I have harmed in the past. In other words, paying it forward whenever I can, and working forever to change that stigma of once an addict, always an addict. And one of our steps in Narcotics Anonymous, which is step 9, to make direct amends to make amends to whenever possible, except when to do so when injured them or others. Some of those people I owe amends to fall under that last part, and the best I can ever do is not to be that asshole I was years ago, and try to be the best person I can every single day, and not go back to that process where I was being a using addict. I owe it to my parents who helped me in my recovery more times than I like to admit. I owe it to Judge Allen who I wrote a letter to thanking him for sending me to jail and the treatment, and who saw something in me 25 years ago that I did not see myself at the time. I owe it to Jonathan and Shannon, who I can only make direct amends to by not being that same person I was that 25 years ago. I owe it to a lot of other people that helped me along the way. I owe it to other people whose toes I stepped on along the way also. But most of all, I owe it to my dog who's been there for the past 12 years, who's been with me for some very dark days in my recovery. Most of all, I owe it to myself. And thirdly, but last but not least, sentencing. I know I'm looking at a decent amount of jail time or prison time. I will do almost anything to avoid going to prison again. Been there, done that, and I would do anything to avoid it. I promised myself that I would never go back. Not after what I've been through the last time I was there. And remember that mindset mentality that you have, it's even worse in prison. I'm afraid to fall back into that again. I worked too hard, too long, to get out and stay away from that mindset. I would do any amount of work release. I still owe my lawyer some money. I would do any godly amount of community service you would like for me to do. I will even work it off helping across the street building a new jail. I know basic plumbing, electrical, I even know welding. If not any of those, I'm pretty sure they can find me a few hours a day. They can find me something for me to do. I'll do any amount of probation or jail time. I will do any amount of probation or house arrest. I could help around the jail. I could fix the tile up front. I could help with a JT program with almost 25 years in recovery and with 14 years clean stretch. I believe I'd be a big asset to you. I know I'm not. I guess what I'm trying to say overall is that I could be a bigger asset to you and to the court rather than being another empty, useless body inside the walls. I will do anything to get me out of here and back to my dog. Her time is coming to an end soon. I would really like to be there when it does, just as she has been there for me. Thank you for letting me speak to this. Sincerely, Dale Setzer.
Thank you, sir. Martinez?
Your Honor, we are asking the court to consider imposing a minimal prison term on community control sanctions if the court disagrees with that, a minimal prison term on Mr. Setzer. Respectfully, it's our position that this was reckless conduct here at the most. Obviously, the jury didn't see it that way. Mr. Setzer did testify. I'm not going to belabor what was said here in open court at the trial. Mr. Setzer, as far as the seriousness and recidivism factors under 29-29-12, we would submit that the assault charges encompass one of the seriousness factors, or within that seriousness factors that victims do suffer serious physical or psychological harm as a result of this offense, so it's not more serious than an average.
Not with count 2 and 4.
Pardon?
One, not with the count he's being sentenced on. I think that one, correct me if I'm wrong, is cause or attempt to cause physical harm with a deadly weapon.
That's correct.
So it doesn't have to be serious physical harm. It can just be physical harm.
Thank you, Your Honor. Respectfully, it's our position that Mr. Kiedis had some role in this. I know, obviously, the evidence was presented here, but he was obviously driving recklessly on that day and caused this. Mr. Setzer, he talks a little bit about his addictions. He did have some problems about 25 years ago. He was in and out of the courts. He served a brief prison term out of Cuyahoga County about 30 years ago. Then he was in and out of the courts for, by his own admission, some drug issues, primarily with marijuana. And Judge Allen did send him to jail treatment and to the Salvation Army program. And since then, Dale's led a law-abiding life for a significant number of years, and I think that needs to be taken into account. He has elderly parents he wants to assist. They're, I believe, 87 and 84 years old. Mr. and Mrs. Setzer has got an elderly dog that he wants to be with. So, he feels remorse for these people. He didn't want anything to happen. He went in and talked to Detective Sergeant on that day, or the next day, told him what he believed happened that day. And it's our position that this is not more serious than the average offense, that even though there are some recidivism factors as it relates to his past criminal conduct that occurred a significant number of years ago, he does demonstrate genuine remorse, and we would ask the court to take all that into consideration in fashioning an appropriate sentence in this case. Thank you, Your Honor.
Thank you, sir. On behalf of the State of Ohio,
Thank you, Your Honor. The state is requesting a prison sentence here in the amount of 9 to 11 years. The defendant has maintained that his conduct here was an accident. However, it was assaultive conduct. He talks about this assault like it's something passive that happened to him, rather than taking any sort of accountability for him causing harm to others. This doesn't have anything to do with him being an addict 25 years ago. This doesn't have anything to do with his drug use. This has everything to do with his state of mind and his behavior towards other people on the road in August of 2024. There's a presumption in favor of a prison sentence on these felonies of the second degree, and factors that would tend to support that are that the victims here did suffer serious physical harm. We had John with broken bones in his foot and ankle. We had Nora suffering a concussion. Nora's injury in particular was exacerbated by her age. She was only 5 years old. We heard testimony that she was supposed to start kindergarten the week that this concussion occurred, that it was very hard for her parents to be able to treat her the appropriate way for that concussion because she needed to rest. She's only 5 years old. She wasn't able to rest. It took longer for her to recover. She had to go to school. There were things that needed to be done. Additionally, there's lasting pain from that. John Cadis still suffers pain in his foot. He described that as an arthritis-like pain, something that hasn't gone away, this kind of constant ache in his foot. All of our victims here suffered serious psychological harm. Nora had to start therapy at only 5 years old. She's still in therapy. The court heard testimony about how she's afraid to ride in her parents' car on the highway, how she gets nervous. She asks her parents if they're going to go on Route 2. She's scared to get on the school bus because she thinks they might go on the highway. Her mom has to attend field trips with her in the event that they might go on the highway to get somewhere because she has that much of a fear from this. We heard that Allison also was impacted by this. Something that was a normal, everyday part of her life, driving down the highway as a 30-year-old woman, now frightens her. When she has to get behind the wheel on the highway, she gets sweaty, she gets nervous, she shakes, and she is fearful for driving with her kids in the car on the highway after this happened. We heard how John has night terrors, that he has trouble sleeping as a result of this assault that happened to him. We have 3 different victims here that suffered serious economic harm. Roseanne Carosi had to pay $10,000 out of pocket for a new car that she needed to purchase. Her car was totaled as a result of the crash. She was in that Ford that was the 3rd car that was hit by the Subaru. John Cadis has over $30,000 in medical costs incurred because he didn't have medical insurance at the time that he was hit. All of his debts are currently in collections. He's responsible for those from the harm that the defendant caused. The Stinsons struggled with their insurance company to be able to replace their Subaru. At one point, they had to sell their second vehicle to buy 2 new cars so that they could live their daily life. All of the vehicles involved in the crash have been housed at the Willoughby Police Department since August of 2024 because they've been held as evidence. So this has been an economic harm and an economic loss to everyone that was involved, everyone whose car was hit as a result of the defendant's conduct. Here, recidivism is more likely. The defendant does have 1 prior felony and served a prison term, although we do acknowledge that that was nearly 30 years ago. The defendant has 13 prior misdemeanors. Those are also older. He has numerous traffic violations. But what's most concerning to the state of Ohio here, and what we think is the most indicative of recidivism, is the defendant shows no genuine remorse. The defendant has repeatedly said that he feels bad for the people involved, but takes no responsibility for assaulting anyone, for hitting anyone, for causing the harm here. He really looks at this from like a passive view that something happened to him. He repeatedly testified to this all being John Cadis' fault. He testified to cursing out the motorcyclist, this being the motorcyclist's fault. In his pre-sentence report, he called John an idiot. In the calls that he's making from the Lake County Jail after being incarcerated, he's making statements about how all of this happened because of an asshole motorcyclist. So the defendant still maintains that this wasn't his fault. He's maintained that all of his senses must have failed that day.
What?
His senses must have failed. There's no way that he didn't see, hear, or feel a thing when he crashed into John and that Subaru rolled down the highway. He put pedal to the metal and hoped that nobody would find him. When he was found, he lied about what happened. It's pretty clear from his statements that his mindset is that he doesn't want to be in trouble or go to jail. His mindset isn't that he doesn't want to cause harm to others around him. He's repeatedly said that he doesn't want to get in trouble. He doesn't want to go to jail. He doesn't want to be locked up. Not that he wants to take care of those around him, not that he wants to be a good citizen, not that he wants to look out for the others on the road, not that he doesn't want to commit crime. The defendant's own intentions have been clear all along, and we heard from his own mouth, this isn't going to end well for you. You're on a motorcycle, I'm in a car. He knew he was wielding a deadly weapon, and he knowingly used it to cause serious physical harm. That's why the state is recommending that the defendant serve a prison term that's substantial. It's necessary to protect the public from his conduct. The defendant told us that there was no anger, no road rage, nothing. He said that to the police. He said that at his trial. He said that to the probation department. And what's really concerning to the state is if that's the defendant not angry, just imagine what he would be like if he truly was angry, the harm that he really would cause if he was in a fit of rage. That's why the state's asking for the defendant to serve an indefinite term of 4 to 6 years on count 2, the felonious assault against John Cadis. We would ask for the mandatory Class 2 driver's license suspension to be imposed and ask for the maximum of a lifetime suspension. We ask for a prison term of 4 years on count 4, the felonious assault against Nora Stinson, and the mandatory Class 2 driver's license suspension, the maximum to be imposed of life, and a term of 12 months on count 8, failure to stop after an accident. There's a Class 5 suspension mandatory with that of 6 months to 3 years. We would ask for the maximum suspension on that of 3 years. Victim John Cadis has provided documentation to the court for his medical bills. He would ask for restitution. Roseanne Carosi is not requesting any restitution be ordered, and the Stinson family has conveyed through the Victims Advocate's office that they are not requesting restitution. However, they will be pursuing civil action against the defendant. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation. I received multiple victim impact statements. I've read and considered all of those. I have the opportunity to preside over the trial. I've considered the facts and circumstances, nature of the offense involved. I've considered everything said here today by Mr. Martinez, the defendant himself, read a statement, the prosecutor's comments, the recommendations from each party. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating the conduct is more or less serious. First off, both victims in counts 2 and 4 did suffer serious physical harm. Again, that's not even required to commit to it. Counts 2 and 4. There's physical harm or attempt to cause that. You don't even need to have any harm. But in this case, they both suffered serious physical harm. Stinson family and the victim in that family, in particular count for count 4, also suffered serious psychological harm. For count 4, the injury was exacerbated due to the young age of the victim. The court also believes that the evidence in the case established not only that was the conduct knowingly, it was done intentionally. The defendant intentionally hit that motorcycle, which is a mens rea that's even more, that is required for the commission of this offense. There's no factors indicating the conduct is less serious. As for recidivism factors, the court will note the defendant does have a history of criminal convictions. He served a prison term before. He's not responded favorably to, well, let's strike that. He served a prison term before. There is no genuine remorse. There's no remorse, let alone genuine remorse. The defendant completely denies any knowledge that he struck the vehicle, any knowledge that there was an accident, and that just defies the evidence that was presented in this court. Defies common sense. Even if to deny knowing that even an accident was called when cars are rolling down the freeway, it's not true. And you could say you're sorry to the victims, and including Mr. Cadis, but then you make these comments about Mr. Cadis with this inappropriate backhanded shot you're taking at him, telling him that you see a lot of him in you, or a lot of you in him, that he's an addict, and refer to him that way. You don't know him. How do you know him that you can stand up there and make any statements like that, except it's an opportunity for you, again, to take a shot at him. And it shows that there's no remorse, and the remorse that you're at least trying to put forth is not genuine.
Your Honor?
No factors indicate recidivism is less likely. Is there something you want to say?
Yeah, I wasn't trying to take a shot at him. My lawyer, Mr. Hector, gave me his past about his DUIs and OVIs and his drug positions, and that's what I had in the past. That's the only thing that I was saying about that.
There's no reason for you to even say that. Even if it's true, there's no reason for you to say that. Why are you giving a diagnosis on this victim or making comments about him in that regard? There's no reason for you to be saying anything like that.
Okay.
That had nothing to do with this case.
I just saw a lot of him in me, that's all.
All that conduct had to do at the bottom of that ramp, and he was wrong in what he did. I don't disagree with that, but the only relevance it had in this case really is that it put you in a rage.
There was no rage, Your Honor.
You're
Honestly,
lying.
there wasn't. There wasn't.
You're clearly lying.
No.
Based on the evidence that was presented. The comments that you were making, I forget exactly what it was said by the prosecutor that you're going to lose, you're on a motorcycle and I'm in a car or truck, whatever he said. It shows that that's not the case. And the other comment that you made, which I think is very relevant here today, that wasn't brought up, is that you made a comment then that actions have consequences. That you cut me off, you didn't engage in that conduct, you made that choice to do that, and now there's consequences, you're going to pay for that. Well, you know what? Actions have consequences. And you decided to do what you did on that day, and there's consequences for that. And that's what's going to happen here today.
I understand that, Your Honor.
Go ahead. I'll let you say what you want to say, but I've already given you a chance to say what you want to say. But if you want to say anything more, go ahead. This is going to be the last chance, though, because I've given you a chance. I'm speaking now, but go ahead, Mr. Setzer.
My aspect of that consequences, your actions consequences were, I lost my license for 15 years because of my consequences and my actions. It took me 15 years to get that license back. That was asking for rides. That was doing everything I could do in every kind of...
You know what, I gotta stop you. I don't need your interpretation of what you meant to say. What you said was actions have consequences, and that was prior to what you went ahead and did. And you said, this is not gonna end well for you. You're in a motorcycle, I'm in a truck, or I'm in a car. Those were all comments that were made after he cut you off, as you're going up the ramp. Clearly affected you the way I said it affected you.
Not really.
Enough.
Sorry.
Because you're digging yourself a bigger hole here. Because you're clearly not being genuine. Because the evidence defies everything that you've said. The eyewitnesses defy everything you said. Your own words defy everything you've said. You're saying. There's a presumption for prison in this case. Well, let me go. I didn't finish my recidivism factors. I will note under the less likely that the defendant has led a law-abiding life for a significant number of years. While there's a significant criminal history, the last thing that happened, I think there was a disorderly more recently, but aside from that, it goes back at least 20 years, and I will note that. There's a presumption for prison. It's not overcome. Prison's consistent with the purposes and principles of sentencing. You refer to this as an accident, reckless conduct. I don't see it as reckless conduct. It was intentional conduct. And it wasn't an accident, it was an assault. Prison is consistent with the purposes and principles of sentencing. You're not amenable to available community control sanctions. Therefore, it will be the sentence of this court. First off, I will make the findings that the parties agree to. Count 1 and 5 will merge with count 2. Count 3 and 6 will merge with count 4. Count 7 will merge with count 8. Those are the counts that the state elected to go forward on, counts 2, 4, and 8. On count 2, it's a sentence of this court. Defendants serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. On count 4 is a sentence of the court. Defendants serve a term in prison of 4 years. On count 8 is a sentence of the court. Defendants serve a term in prison of 12 months. Counts 2 and 4 are ordered to be served consecutive to each other. Count 8 will be served concurrent to the sentences in 2 and 4 for an overall aggregate total indefinite prison term of a minimum of 8 years, maximum of 10 years. There's credit for 43 days the defendant's already served. The court further finds that the deadly weapon used in counts 2 and 4 was a motor vehicle. And accordingly, a mandatory license suspension is required to be imposed for counts 2 and 4. And it's ordered that a mandatory life suspension be imposed for counts 2 and 4, 3 years for count 8. An order restitution, Mr. Cadis, John Cadis, in the amount of $33,248.85. Those are his medical bills that he has incurred. He has no insurance. Those are all in collections. I will permit those, or order that those be offset by any insurance proceeds that the victim may receive. And Mr. Martinez, if you need to file something down the road to modify that based on information received at some point regarding any proceeds received, the court will certainly entertain that. Defendant's ordered to pay all costs incurred in this action.
Judge, what was the suspension on counts 2 and 4?
A lifetime revocation. If I didn't say that, I apologize. Lifetime suspension on 2 and 4, 3 years and 8. Is there anything else for the record at this time, Ms. Tuttle?
Just the appellate rights, Your Honor.
Oh.
Thank you.
Thank you. I need to advise you, Mr. Setzer, that you do have the right to appeal the conviction in this case. Specifically, if you're unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, the court will appoint one for you to represent you and pursue that appeal without cost to you. If you're unable to pay for the cost of documents necessary for an appeal, which includes a transcript of all the trial and all the other proceedings we've had here in court, those documents will be provided for you without cost. And you have the right to have a notice of appeal timely filed on your behalf. Ms. Martinez, do you know what the defense intention is at this time regarding, are you going to be representing him on appeals? Are you going to need someone appointed? You don't know that yet?
I don't know yet, but I'll make sure that I either file a motion to appoint someone or file the appeal on behalf of Mr. Setzer.
Yeah, and minimum, even if you're not going to do it, if it's coming close, you can file a notice of appeal
Correct.
and get someone appointed after that if you need
Always
to do
that. Yes.
Lastly, the court finds in this case for counts 2 and 4 that consecutive service is necessary to protect the public from future crime, to punish the offender, that the sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that these two offenses were committed as a part of course of conduct, and that the harm caused by these two counts, these two offenses, is so great or unusual that no single prison term for any offenses committed as a part of the courses of conduct adequately reflects the seriousness of his conduct. There's two separate assaults here, two separate victims. Should be separate punishments that should be served for each of these acts and should be recognized for each of these acts. And that's why this consecutive service is appropriate and necessary.
Your Honor, also mandatory post-release control advisements since it's a felony too. Assault.
Thank you.
Thank you.
Lastly, I need to advise you that upon your release from prison, you will be placed on post-release control, in this case for at least 18 months. could be up to 3 years. It's mandatory. While on post-release control, if you violate any of the conditions of post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall total of 50% or half of the prison term imposed by this court. And one last thing. I also need to advise you for the record here, Mr. Setzer, that you have been sentenced to a non-life felony indefinite prison term. And in regards to that, there is a rebuttable presumption that you will be released from the service of that term after you have served the minimum sentence of 4 years. Now, that is not guaranteed. There's a presumption that you'll be released at that time, but that is not guaranteed. I've had a hearing. The Department of Rehabilitation and Correction has a right to rebut that presumption at a hearing, and if they present evidence at that hearing that you have committed institutional infractions of the rules, not conducted yourself in accordance with the rules, if you misbehave, basically, if you're not sufficiently rehabilitated, if you pose a threat to the community, if any of that is established, that presumption would be rebutted, and you would not be released at the end of your minimum sentence. The department would select a new date that would represent your release date, and there would be a presumption then at that new date that you'd be released, unless again it's rebutted by evidence presented that you are still not sufficiently rehabilitated or still being a threat, or they continue to violate the institution's rules. Under no circumstances, however, can you be kept in prison beyond the maximum sentence of the 6 years that was imposed. All right, I think that covers all the things, advisements that need to be said. Is there anything else, Ms. Tuttle?
No, Your Honor. Thank you.
Mr. Martinez.
No, Your Honor. Thank you.
Okie dokie. Let's go back to Judge Stevens. That defendant that was in front of him earlier is back.
Go ahead.
Parents, the client, and before he was committed, he was seeing 4 different doctors for his conditions.
Yeah.
We would ask for the court to release him back out, and we're going to continue up with Mary Vogt, MD, Houston Methodist.
Yes, take it slowly.
Neurologist, Maria DeLay, PhD, Houston Methodist, neuropsychologist. Mario. I put it. I just misread it. Patricia Salvato, that's his PCP in Houston, MD, and then also Sherrod Kilcarney here in Beaumont, psychiatrist. And if you can release him back, so he can get back to being treated for those doctors, that will be an outpatient treatment.
What's they say on there?
Your Honor, if he is released today, we do ask that the no contact order with the victims remain in place.
Well, I only have one victim here, right?
Yeah.
What's the victim and his
Peyton.
His wife next door. There were neighbors. Judge, the concern I have, what were all those doctors? They treated him before, right? Before all this happened? And he became incompetent. One of them is a psychiatrist.
Yeah, Carney.
Are any of them other treat any type of mental disability, or are those just physical?
One of them is a neuropsychologist. That's a delay. One of them is a PCP, which is, we understand that's not part of this.
Okay.
And then one of them is a neurologist.
So if they do that, we need to have make sure that there's an order, make all appointments, they take all medications, and that there be someone to be able to supply us with information that he's taking his medications and doing what he's supposed to do.
That's legal.
There's still a gap there. He's deciding when he goes to see them.
Right.
He's deciding.
That's why
there's help. That's not going to work.
You ask us what we want. That's what we said.
Why don't we have defense counsel contact them and find out what the regimen is so that we can determine what the regimen will be by the doctor, not by the patient.
Where will you be staying when you're released, sir?
Possibly with my mother, if not at home.
Is that at 9? Is that at 9 Winchester?
My home is in 9 Winchester.
Is that where you will be living, sir?
Yes.
Okay.
Yeah, the alternative is 9120 Garden.
And who lives there?
My mother.
Okay. So the defendant will be ordered to stay at either of those residences.
Sure.
That will be his residence that we will expect him to continue to live at. And then the 3 doctors.
It's Mary Vo. That's VO, correct?
Mm-hmm.
Okay.
VO or VU?
VO, whatever. Yeah.
And where is this physician? In Beaumont?
Houston Methodist. I keep saying Methodist wrong.
Houston at Methodist Hospital?
Methodist, yeah.
And
Mario.
Hold on. One at a time. On this one, Dr. Vo, what does Dr. Vo do for you?
She's a neurologist.
And what is she doing?
Oh.
How is she treating you?
Not
she's treating you politely. I mean, what methodology is she using to help you?
I was sent to do an assessment that consisted of an MRI and an EEG.
Does she see you routinely though, or was she just to evaluate you with an MRI?
Taking over for Erica Green, MD, at Houston Methodist.
So what does that mean? Does Dr. Vo see you regularly?
I haven't. I was
when you're released.
I was supposed to be starting up with her.
Okay, how often?
Well, that's to be determined by her. But I couldn't see Erica Green because she's got a full plate.
A what?
Too many clients.
She's got too many clients. So I was supposed to start up with Mary Vo.
Okay, we'll be replacing the other person.
I see Mario DeLay annually.
Hold on. And where is Mario DeLay's office?
Houston Methodist.
At the same place?
Yes.
Is it DELAY?
DULAY. PhD.
Houston Methodist, right?
Yes. I see him annually, if not twice a year.
Who decides that? He does?
I keep up with it all the time.
Okay, then
I always finish my
more often the better. So twice a year will be ordered at least twice a year. Okay. So third one.
It is Sherrod, Dr. Sherrod, S.H.
That silly judge. I hate it when he does that. But oh well, what are you going to do? It's just about the bottom of the last hour of Friday. We know what that means. It's been a tradition for the last several months now when we can pull it off, when they're in session. It's a dank, dark basement. Carpet ripped straight out of The Shining, lighting circa Soviet Cold War, a cranky judge, spirits of the dead, torches burning in the background. All that fancy stuff, ladies and gentlemen. For the end of the day, I present to you Dungeon Court.
Here, Mr. Urban. Nice to meet you in person.
Hey, Your Honor, there was some confusion about whether Ms. Williams had gotten here yet or not, but I just realized she was here to confirm that Ms. Arvin. Spoken to Ms. Williams, she's prepared to speak to Ms. Arvin. I don't know if Ms. Arvin is going to speak directly with her or make arrangements for somebody.
When she gets back to the jail, I'll have permission to call over.
Okay.
And, do a screen on these boards. And I, tell them when hopefully, because I know she needs to see her on, I'm going to back up.
So for the moment, I think the best thing we could do would be to set this matter for next Friday. I'm not going to be here Tuesday, but I will be here Friday.
Well, and I would be, because we've done this on some of the others, if she's assessed and they think she's appropriate for treatment, I would be willing to enter an order that she be transferred there if that's agreeable.
I've spoken to her. I think she is agreeable that we spoke briefly in the back. Well,
You're looking at 6 months. That doesn't make any sense. Just like the last gentleman, that doesn't make any sense.
I would like to at least, my advice to her would be not to enter a guilty plea at this time. At least give us a week to try to figure things out. If at the end of that, that's her decision, I work for her. As long as stuff to do isn't illegal, I'm going to do what stuff to do.
Well, that is, she's competent to make that decision, and I think there's an
exactly.
issue on the record is whether she's even competent to make that decision.
No, there is that as well. So I would ask for a continuous for 1 week.
We'll set it for a pretrial next Friday, but I just put it out there that it is possible that if she would go to treatment, it can happen before then.
And I'm going to ask her that happen. She's agreeable.
Yes.
I'll speak to her again.
As of now, October 17th for a pretrial. It was set for the 14th, and Mr. Steyer's not available.
Thank you.
You're welcome.
State of Ohio versus Dillon and Dare, case number CRB 25609.
So we've done the assessment. So I think the clinical.
So I'm going to say, to back in the jail, I'm going to have the shop tissue call over and do what we did in the previous one. If she says it meets criteria, we could get a transport order to have it brought over. And then I told him on their real work on what it looks like next for him, just like we did for the other one, whether that be treatment options or what we can do to try to get him some, he's almost from what I can gather. So we will try to get him into something secondary.
And is he agreeable?
Yeah, that's right.
All right, so I'll do an order if he's assessed and is recommended for treatment at Bellefonte.
What time does she get back over to the jail?
Well, whenever court's over, we're finished with them, then they can leave, so it'll be this afternoon. Should be early afternoon, they should be back.
Okay, I'll be there and I'll keep you guys updated.
Thank you. So do you want to just go ahead and set another pretrial in case it doesn't happen? What's your availability?
Everything except the 14th.
Okay, so we'll put it on the 17th.
Yes.
Okay, Mr. Adair's next hearing will be the 17th. And like the last case, I can do an order allowing him to go to Bellefonte for treatment if they deem it necessary appropriately.
Orders
Yes.
afterwards, you don't want me to type anything.
Well, we use the same one we did for J.B. Moore. Oh, Missy did it. Okay, there's one that's.
In the dark on this.
Okay, there's one, there's been an order prepared, so we've got one that's, just needs to be modified.
State of Ohio recall state of Frazier, case number CRA 25619, CRA 25621, A and B.
Mr. Stratton's case, 25-619, 25-621. The 619 is the issue, that's the first parole violation, actually, not probation violation out of Kentucky. And there's a holder on that. He's willing to waive extradition to go to Kentucky.
We'll waive extradition to Kentucky, I understand the state law dismisses this.
Well, it can't be dismissed, it's just gonna be held until he's either transferred to Kentucky or, oh, the felonies, yes. Those are, well, they're gonna be nominal. Okay. So the intention of the court is that the holder from the parole violation in Kentucky is gonna stay in place.
Yes.
That he's giving up the right to hearing to determine whether he should go to Kentucky or not. He's agreeing to go to Kentucky.
He is.
So I'm going to leave it, normally we would notify Kentucky to come pick him up, but I'm not going to do that now. I'm going to leave it to Judge Ballard, or one of the common pleas judges, I don't know which judge, to make that call. Okay. All right, the 25-621 A and B are nolly to the grand jury. 25-619 is waived, and it'll go to common pleas.
Yes, Your Honor. I mean, if he's released, then one can hold him to Kentucky to come and get him. As for being released, if they don't come and get him, that's what
Okay. Well, I'm not going to make that call, but he's waiving his right to hearing to determine whether he should go to Kentucky.
Right, yes.
State of Ohio recall Emily Smith here at the court, case number CRB 23627. Emily Smith here at the court.
So, Your Honor, I had spoken with Hope Source, and she had completed on October 7th. Huh? She's a star? Okay, well, there you go. I didn't see you. You must have came late. Oh, did you? Okay. All right. Then she's a star, Your Honor.
All right, so apparently she's got something from our common pleas court. What's the state want to do with this?
Well, this is
It's an old case, and
23 theft charge and disorderly conduct.
I just have one charge. It's complicity to commit theft.
She pled guilty already, and been going through treatment.
She's a star, Your Honor. She's going to be under common pleas probation when she leaves.
I'm fine from my knowledge.
Yeah,
The whole idea was getting her into treatment. She's been multiple times. This is and she's had problems with treatment.
Yes, actually, it was the more recent charges that ended up in common pleas, and that's why she's a star. So yeah, we would agree to nolly everything that's pending.
All right. Matters here are nolly because she's in star and under the supervision of common pleas. Smith, they run Nolly 23627.
State of Ohio versus James McClaskey on recall, case number TRC 19975 A, B, and C.
All right, Mr. McClaskey's at amended readings, and we're going to give a report.
They was thinking John.
Your Honor, it's maybe recall, he said it was sent to Mr.
Can you give me a verbal?
Yes, he's been non-compliant in this last drug screen, so.
Okay, well, I'm going to need it then. So we'll recall, go ahead and give me the written report.
Would you like him to drug screen today, Your Honor?
Yeah, let's do it. Screen today.
Yeah, let's help him.
Better preparation to drug screen.
Yeah, let's help him, mechanism. Forward him to get some money to pay him, but yeah, you can go and see.
Okay, we'll do a drug screen.
State of Ohio recalls Garrett Lee Hosey, case number TRB 25546.
I've seen the results, Your Honor. The alcohol and THC speak for themselves, probably. My understanding is there was a test for amphetamines. Mr. Posey has informed me that he takes Adderall and has for a long period of time. That's consistent with my understanding of his mental health treatment that he's undergone up to this point. Now, he spoke to, who are you going to again? Hometown? Lawrence County Recovery.
Yes, I just called.
Lawrence County Recovery, and they have made a new appointment for him. What day is that?
Monday.
For Monday. I would ask if we could set this thing back for next Friday and see if he's gotten himself straight with the provider. Now, if I recognize that if the court does this, we're going to want to see that he went, completed the evaluation, did anything in the meantime they told him to do.
And the other thing you need to make them aware of is that he tested positive for THC and alcohol. And I'm going to go out on a limb here and say that if you read the instructions or the booklet that comes with Adderall, it probably says you're not allowed to drink alcohol while you're taking the Adderall. It's contraindicated. So, reschedule this for October 17th for pre-trial, 10 o'clock.
Can you leave just until you got to stay and do the assessment? Well, you still got to be there anyway. Be here anyway. Thank you, Your Honor.
You're welcome.
State of Ohio versus Adam Searles, case number CRB 25646, A and B. Set for arraignment.
And it's a new charge. Adam Searles.
Yes.
Yeah, we don't have it. Sir, are you Adam C. Searles?
Yes.
Okay, we do that. We'll call, there's a companion thing to call.
State of Ohio versus Courtney Searles, case number CRB 25645.
And ma'am, you're Courtney Searles.
Yes.
And it looks like you're both charged with domestic violence. The complaints alleged on October the 6th this year, Rome Township, you not only caused or tried to cause physical harm to each other, and that you're members of the same family or household. That makes it a domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. And then, Mr. Searles, he also has another charge. That's the only charge for you, ma'am. For Mr. Searles, he's also charged with disorderly conduct. that at the same time and place he caused inconvenience, annoyance, alarm to others by engaging in fighting, threatening to do harm to other persons or their property, being violent or turbulent, and this was committed in the presence of a law enforcement officer and persisted in after being warned to stop. So that's a 4th degree misdemeanor disorderly conduct. Maximum penalty for that's 30 days in jail, $250 fine. Do you each understand the charges?
Yes.
Do you understand the rights defendants have? I explained at the beginning of court.
Yes.
Mr. Searle?
Yes, I understand the rights.
How do you each wish to plead to the charge?
Not guilty.
Not guilty.
Do you wish to be considered for court-appointed lawyers?
No, I'm in the process of hiring Mark McCown.
Mr. McCown?
Yes.
What about you, ma'am?
I need to be appointed a lawyer if possible.
Okay, are you working?
Yes, but I've only worked for a month and a half.
What do you do?
I work for Macon Construction.
Are you paid by the hour?
Yes.
How much per hour?
$15.
How many hours a week?
40.
How many kids? Do you have kids?
I have 3.
Okay, you're eligible. I'll ask Mr. Steyer to represent you.
Your Honor,
Yes.
can I ask a question?
Yes.
My husband has been holding my personal property in our marital home, and because we have no contact, I have not been able to retrieve any of my personal hygiene, my feminine personal hygiene. I haven't been able to get any of my government documents that are locked in a fire safe. Is there any way that I can get a court order to have someone go up there with me so I can retrieve my things?
We may be able to handle that
Okay.
here in just a second.
They both have bonds up to Mr. Salaries.
Have you hired Mr. McCown yet, or are you simply speaking to him?
I have him for the divorce, but he's supposed to, his dad passed away last week.
Right, that's, well, yeah.
So I paid him retainer for the divorce, and he's going to represent me on this also.
Okay, I can arrange with Mr. McCown for you to the belongings.
Okay, how soon? Because
I don't know how soon, but I can do it as
Okay,
quickly as I
because
can.
I don't even have my medication.
I understand.
Okay.
Okay.
I think we can deal with that through Mr. McCown's office, probably.
All right. It sounds like, is there protection orders requested from each of you to stay away from
For the
other?
moment, mutual protective orders may be a good idea.
All right, so I'll order you both to stay away from the other. Don't go around, don't contact, and don't post things on social media about each other.
May I ask another question?
Ask me. Probably should ask Mr. Scott.
I have a legal question. Can I get like an attorney that's temporarily until Mark's here?
Yes, can we do that?
Great. Would you be agreeable to dropping the mutual protective orders if she was agreeable to that?
Can I get like a temporary attorney? Because there's.
I can't give you a temporary attorney.
Well, like, because Mark McCown's not here and I don't want to agree to anything, you know.
Well, if you want to go call him, I can recall it.
Well, let's do that, and that'll give me a chance to speak to her off the mic. And
Sure. All right, and maybe we can resolve some of these issues about property.
Yeah, we can. Thank you.
All right, these cases will both be recalled later in the document.
State of Ohio recalls James Brzezinski, case number TRC 19975, A, B, and C.
Do we have a?
So he hasn't done anything.
I called on my last appointment Tuesday. Because I was helping my cousin put a laminate floor down to get some money to pay this off.
So I believe his screen was fine today, Your Honor. So-
THC.
Okay. It is set for sentencing?
Yes. He's supposed to be going to amended reads for some counseling, and they're saying he's not participating.
I missed the last one because I was helping my cousin put a laminate floor down so I could get some money to make my payments here and pay some bills.
Well, they're saying.
And I called them and they said it was fine. I called him that morning before my appointment. And I didn't know that I could go in there after hours to do the drug test, or I would have, because I ain't dirty on nothing.
Smith, is Bree still willing to work with him?
Yes, we will work with him.
Okay. Get it done, and you got community service to do and fines and court costs to pay.
That's what
You got
they,
36 hours.
I'm supposed to get paid this evening, and I'll drop some money off, probably it'll be money. I think I can do it over the line, can't I?
I'm sorry?
I can pay over the phone?
No, you can pay on a computer, or you can have to come in person. You can't
Oh, okay.
All in and pay. You got a smartphone, you can go on there.
No, I got a dumb one.
Okay. Well, everybody's got a smartphone now. I don't know. Get a 12-year-old, it probably looks like it is a smartphone. Find a 12-year-old and they'll show you how to get on the court's website and make a payment.
My niece could do it.
Then, you got 36 hours community service still.
Yeah, and Kincaid's supposed to look, because he said some of the hours that I did down there, they think they put them on my son's case down there because of the last name. But he's supposed to check and see for sure, but.
Okay, well, keep after it, get it, you know, they haven't told us that you did the hours.
Right, well, that's the reason why he's checking to see.
Okay, November the 14th will be the next hearing.
Okay.
Is that, you are available then?
Yes, Your Honor.
Okay, November 14th. Get it done.
State of Ohio versus Beth Igo, case number CRB 25644.
This is an arraignment.
Yes.
Are you Beth Igo?
And you're going to be representing her, Mr. Morford?
I am, Judge.
Do you wish me to read these charges into the record?
I would waive reading, Your Honor. Ask you to set an OR bond. She's appeared here voluntarily.
She has a bond up.
Oh, she did? But
She posted a bond with Mr. Sellers. According to,
we'd ask you to continue that, then.
I will continue it. And there are not guilty plea. When do you want to come back for pretrial?
You want to do it the 27th, Judge,
That's fine.
of October?
October 27th, do pretrial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Larry McNamara, case number CRA 25647.
Ma'am, who are you?
I'm Kayla. I'm staff at the treatment facility he's at.
Oh, okay. What facility is that?
Serenity Springs.
Thank you.
Where is that located?
Ashland.
Should be in the file.
All right, this is your arraignment. You are Larry B. Is it
McNamer?
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 McNamer. All right, Mr. McNamer, you have a possession of cocaine charge. That's a felony of the 5th degree. Did you hear when I explained defendant's rights?
Yeah.
So you understand your rights?
Yeah.
Possession of cocaine is felony 5, maximum penalty is a year in jail, $2,500 fine. The state's alleging that at Union Township, October the 8th, you knowingly obtained, possessed, or used cocaine. Do you understand the charge?
Yeah.
And you've got a South Point address?
Yeah.
Was he in your facility?
Not at the time.
Okay. So just recently you went there, since this happened? All right, you understand the charge, sir?
Yes, sir.
You have the money to hire a lawyer?
No, sir.
You have a job?
Did.
What did you do?
Case manager at a treatment facility.
Which one?
Restoring Hope.
Okay. Mr. Morford, I'll appoint you. McNamer is his name, Larry McNamer. What's the state's position on bond?
Posted a $2,500 cash bond, it just has not been received yet.
Okay, he's posted a bond, so that is noted on the front file. So, okay, that's continued. Any other conditions of bond?
We would want him to stay in his treatment. We're glad he's already in treatment.
Well, my only problem with that is I don't know anything about the facility. I don't think I've ever worked with your facility.
We've been open since November.
Okay. Do you have the Medicaid card?
Yeah.
All right, well, I'm going to require you to go to a facility that the court works with. He's inpatient with you or outpatient?
Inpatient.
All right, I'm going to, do you have any problem going to a faith-based facility?
Yeah, I'd prefer not to.
Okay. I'll refer you to talk to him and figure out where he's going to go. All right, so go talk to some folks that are here that are going to assess you, and then you come back and we'll finalize things. So I'll recall it. Do not.
All right. Thank you. Yeah, want to figure this out. Go get it set. We'll be back. All right.
State of Ohio recalls Kyle Maynard back in holding, case number CRB 24478.
Your Honor, I'm spoken to,
Yeah.
He's going to go back as TCC's doing the tape.
Okay. That's a much better decision. You have to commit to doing this, Kai, and you can do it. It's not like, there's some people, well, very few, but there are some I feel like they're so far gone, they're not ever going to do it. You're not in that situation. There's so much at stake here. You just have to put your mind to it. I know it's difficult with the circumstances you're in because of your wife. But you've got, she may be out of the picture now because she has a trafficking charge. What? How? How's it changed? Is there a case going away?
I think you talk about it.
Well, that's what I'm saying. She may be out of the picture or not. You know, I think she was a bad influence on you, and she's not going to be there with the child. So you're going to have to pick up the cudgel and go forward, take care of this child down the road, and be a father, that's clean. Okay, that's the goal. I hope today is the last day you ever wear an orange jumpsuit. That's my goal. I get no pleasure seeing you in jail. In fact, it hurts me to see you in jail, because I know your family. I know your mother. And I know this is terrible for her. But my main focus is your baby girl, right? It's a girl. If we do things right, she's going to be alive in the next century. And what you're doing right now is, this is the most important years of her life. She needs you more now than ever. You're laying the groundwork for how her life is going to be. And what you're laying right now is not good. She may overcome it. There's a possibility she could overcome it. But we know statistically, if you got a parent that's using, the chances that you're going to use go way up dramatically. Plus a whole bunch of other bad consequences from that. Have you ever heard of ACEs, adverse childhood experiences? You can add those up and then look at if you look at what people's adverse childhood experiences are, then look at them when they're 25, you're going to see those results. One of the ACEs is having a parent that uses. That's an adverse childhood experience. Having a parent that goes to jail. That's an ACE. That's an adverse childhood experience. Having a parent that's not in the home. That's an adverse childhood experience. The more of those you have, the more likely you're going to have a lot of trouble in your life. And you don't want that. You love this child, right? You want the best for her. You show me that and show her that. Okay, I'm going to order that you go back to the counseling center with a GPS monitor. You cannot leave without permission of the court or permission of the counseling center. If you cut the ankle monitor off, you are going to go to prison. Is that as clear as it can be? And I'm hoping for your success. I want you to be successful. Okay, let's what's your non-availability?
They have that OR.
2,000 OR. He knows what he needs to do. He's been there, and the truth is, when he's there and people are telling him what to do, he does pretty good. It's when he gets out and has to make his own decisions, bad. I'm thinking more like the 1st of November. How about the 3rd? Well, okay, that's middle. 14th, November 14th. Okay, next hearing, November 14th, for a pretrial. 2,000 OR, counseling center with GPS. And I don't know when the GPS is going to go on, because it's hard to get on Fridays.
Okie dokie, ladies and gentlemen, that brings it to a conclusion for today. Michael, thank you for gifting 5 memberships there at the end. I very much appreciate that. I appreciate all of you, not just today, but every day. I've said it a couple times today. This has been one of the best years of my life, and I look forward to spending the next year and the years after that with you guys, because I intend to go nowhere. As long as I have breath in my body, and as long as YouTube doesn't ban me for some stupid reason, as they're apt to do from time to people, we'll be here. Yeah, I hope you enjoyed the day. I know I did. So much so we'll be back on Monday, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. I might bring another surprise or two come Monday, depending on how things go. We're going to continue to grow what we do here, add more stuff to the live show. So we'll see how things develop over the coming days and weeks. And of course, we'll be back tomorrow night Yeah, tomorrow night, Saturday night, for game night, 8 p.m. Eastern, 5 p.m. Pacific, and it looks like we're going to, by vote, be continuing with Unravel, so that should be fun. But go have yourselves a great day and a great weekend, and until the next time I see you, take care. God bless.